The House Judiciary Committee's Subcommittee on Immigration and Citizenship and the House Foreign Affairs Committee's Subcommittee on Oversight and Investigation will come to order for this joint hearing. Without objection, I will preside over today's hearing. In addition, without objection, the presiding member is authorized to declare recesses of the subcommittee at any time. We welcome everyone to this morning's hearing on oversight of the Trump administration's Muslim ban. I would like to welcome the members of the Subcommittee on Oversight and Investigations to this hearing. We are very happy to be working on this important issue with you all today. I'd also like to thank all the majority and minority members and staffs of both subcommittees for their coordination and flexibility while planning this joint hearing, particularly given the cancellation of yesterday's votes. I want to note that because of the cancellation votes, not every member is able to be here today, but I did make a point of talking to Mr. Collins and Mr. Buck to be assured that they were okay with proceeding, and they assured me that they were, especially since Mr. Biggs and Mr. Zeldin will be here. So we do appreciate that flexibility and our opportunity to learn more and to probe issues about this matter. I really do think the hearing in many ways is overdue. For 2.5 years, the administration has been allowed to arbitrarily exclude from the United States individuals from predominantly Muslim countries, and there's been no oversight by the Congress. Today, that oversight starts. As a candidate for president, Mr. Trump promised to ban Muslims from entering the United States, suggesting without evidence that would somehow make our country safer. Immediately upon entering office, he followed through on his promise, only to have his first executive order struck down by the courts as unlawful. It took the president 10 months, 3 attempts, and the inclusion of a waiver process that appears to be something of a sham to create a version of the ban that allowed the Supreme Court to turn a blind eye to the religious animus that inspired it. The administration claims that the ban is necessary to keep our country safe from terrorists, and yet a bipartisan coalition of former national security officers concluded otherwise. According to Madeleine Albright, General Michael Hayden, former Senator Richard Lugar, and many others, overwhelming evidence demonstrates that the ban has failed to advance our national security and foreign policy interests and is, in fact, damaging those interests. Moreover, as we will discuss today, the Muslim ban keeps families apart, harms businesses, and supports the false notion that bad actors are more likely to come from certain countries. This is contrary to our American values and our immigration laws. That's why I've led the House of Representatives in amicus briefs in support of court cases challenging the legality of the ban, and why I'm an original co-sponsor of Representative Judy Chu and Senator Chris Coons' No Ban Act. This legislation would repeal all 3 versions of the ban and strengthen the Immigration and Nationality Act by prohibiting discrimination based on religion in the issuance of immigration decisions and limiting executive authority to issue future travel bans. Today, we will also delve into the waiver process, and rightfully so, since so many aspects of it remain a mystery. The Department of State claims that around 5% of waiver applications have been approved, but standards for granting a waiver appear to be applied inconsistently across consular posts. The lack of an established application process only leads to the confusion caused by the inconsistency and lack of transparency. One thing we do know is that once an individual case is referred for waiver, chances are it will languish in administrative processing for months, if not longer. We will hear today from some individuals who've been stuck in limbo waiting for a decision, victims of this policy who for too long have endured the pain of separation from their loved ones. Some of these individuals have missed the birth of a child, have been unable to start a family, or have had to refuse job offers here in the United States. Delays of this magnitude, where major life events are missed or must be placed on hold indefinitely, are unacceptable. Discrimination based on religion is unlawful and un-American, and until this ban is repealed, I will continue to oppose it every step of the way. Now, I want to thank Chairman Barra of the Foreign Affairs Oversight and Investigation Subcommittee for his work in making today's joint hearing a reality, and also for his commitment to holding the administration accountable for its policies, actions, and statements about the ban. I also want to thank our witnesses, especially those who are here today, to show how the ban has so deeply impacted their lives. Now, although the ranking member of the subcommittee, as I mentioned, was unable to attend today's hearing, I would like to recognize Mr. Biggs for an opening statement.
Thank you, Madam Chair, and I thank the witnesses for being here today. Before I get into the substance of this, I must point out that the title of the hearing today seems disingenuous to me. If my colleagues on the other side of the aisle want to be taken seriously in their oversight of the Trump administration's immigration and national security-related policies, then the least they can do is have the titles of their hearings accurately reflect the issue. But my colleagues have decided to ignore the realities surrounding the executive order entitled Protecting the Nation from Foreign Terrorist Entry into the United States, and instead continue to sow discord among the American people by merely the title of this hearing today. Of course, the 7 countries in the original January 2017 travel executive order were those countries specified by this Congress and the Obama administration as countries of particular concern for terrorism pursuant to the Visa Waiver Improvement and Terrorist Travel Prevention Act of 2015, a bill which the Democrats allowed to be considered on the House floor under suspension and which only garnered 19 votes in opposition. And as the United States Supreme Court noted about the subsequent presidential proclamation, quote, the text says nothing about religion, close quote, and, quote, the policy covers just 8% of the world's Muslim population, close quote. So if the point of the travel executive order was not to ban all persons of a particular religion from entering the United States, what was it? The point of it was exactly what the September 24, 2017 presidential proclamation stated in its title: enhancing vetting capabilities and processes for detecting attempted entry into the United States by terrorists or other public safety threats. It is ironic that my Democrat colleagues are holding this hearing less than 2 weeks after the 18th anniversary of the September 11th terrorist attacks, an attack in which foreign national terrorists exploited U.S. immigration law in order to gain access to the United States for the sole purpose of killing thousands of our citizens. Maybe we need a refresher on the fact that the September 11th terrorists submitted 23 visa applications to the United States government, of which 22 were approved. They were approved despite both blatant omissions and lies in the applications, and they were approved after background name checks were conducted. It was clear after 9/11 that our vetting and screening was insufficient. In the years since 2001, our vetting has remained insufficient enough that we issued immigration benefits to a number of individuals who were a national security risk. For instance, among others, we issued a student visa to a terrorist who settled in Texas, and a fiancé visa to a terrorist who went to California. And just late last week, the Manhattan U.S. Attorney announced the indictment of a naturalized U.S. citizen originally from Lebanon on charges of being an agent of Hezbollah. He entered the United States in 2000 and was naturalized as a U.S. citizen in 2008 despite having joined Hezbollah in 1996 and receiving training before his entry, despite being an operative of Hezbollah's External Operations Unit, and despite receiving explosives trainings from Hezbollah in Lebanon in 2004 and 2005. It is obvious our vetting and screening was not sufficient. Today we sit in a hearing in which my colleagues intend to lambaste an administration for putting forth a policy that, at its core, was meant to increase immigration-related vetting. This president promised the American people he would do that, and he has followed through. Of course, no vetting is perfect, a fact which this administration recognizes. That's why Presidential Proclamation 9645 includes a requirement that, now annually, the Secretaries of DHS, in consultation with the Secretary of State, the Attorney General, and the Director of National Intelligence, update the President regarding procedures related to immigration screening and vetting, with the purpose of enhancing the safety and security of the United States. The initial executive order and subsequent proclamation were based on the President's power under Section 212F of the Immigration and Nationality Act, as well as the President's foreign policy powers vested by the Constitution. INI 212F states that Whenever the President finds that the entry of any aliens or of any class of aliens into the United States would be detrimental to the interests of the United States, he may, by proclamation, and for such period as he shall deem necessary, suspend the entry of all aliens or any class of aliens as immigrants or non-immigrants, or impose on the entry of aliens any restrictions he may deem to be appropriate. Presidents of both political parties have used 212F many times. Proclamation 9645 specified 8 countries subject to temporary travel restrictions due to inadequacy in the country's cooperation with the United States identity management and information sharing policies, as well as the terrorist presence within those countries. One of those countries, Chad, had their travel restrictions lifted just 7 months later after they improved their identity management and information sharing practices with the United States. Proof that the restrictions are temporary in nature. The travel restrictions for each country range from only restrictions on immigrant visas to only restrictions on certain non-immigrant visas to a mixture of both. The state of Hawaii sued to have the travel ban struck down, but in June 2018, the United States Supreme Court reversed a Ninth Circuit injunction finding that the plaintiffs were unlikely to prevail on their claim. Of course, I agree with those who have suggested, such as then Secretary of DHS John Kelly, that the implementation of the initial travel executive order should have been better. It was not rolled out well, communication among government partners was lacking, and there was confusion. Given the importance of the issue to our national security and to those affected, the administration simply should have done better. But only my Democrat colleagues would argue in opposition to heightened security on aliens who seek to enter the United States. President Trump promised the American people his administration would increase U.S. immigration vetting and screening capabilities. He issued an executive order to that effect, a revised executive order, and a presidential proclamation aimed at doing just that. He has been successful in getting the majority of the world's countries to allow us access to better information for the purposes of immigration vetting, and his actions have made us safer. For that, I'm grateful. I look forward to the witnesses' testimony today, and I yield back.
Gentleman yields back. I would now turn to my colleague, the chair of the Subcommittee on Oversight and Investigations, Mr. Barra, for his opening statement.
Thank you, Chairwoman Lofgren, and members of both subcommittees, the witnesses, and public for joining us for today's hearing. The first on the Muslim ban, and long overdue. You know, I have a deep love for the United States of America. And, you know, as you think about it, school children all across this country every day state the Pledge of Allegiance. And in that, you know, the line that has always struck me as profound is one nation under God, indivisible, with liberty and justice for all. Now, as kids, we may not have known what that means. But as we get older and we learn about the Constitution and we learn about our values as Americans, we learn it's about those freedoms, those core values. And core to that is the freedom of religion. And, you know, in this great nation of ours, we don't tell people which God to pray to or how to worship. And that is core to what makes our country great. And when I think about, you know, one of the first actions that President Trump took in his first days in office profoundly went against those values. And that's why you saw such outcry all across this nation, because it really does smack against who we are. Now, we've seen several iterations of that executive order, but, you know, as my colleague, Mr. Biggs, pointed out, you know, this, you know, if we are to be objective and look at the threats and where terrorist threats were coming from, and if the intent here was to keep us safer, we didn't see this imminent threat. If I think about, you know, my privilege now as a member of Congress, I'm not a lawyer, I'm a doctor, and as such, you know, I won't argue the legal side of this one way or another, but I will look for the facts. And that is our job, and that is our constitutional duty as members of Congress, to conduct oversight. If we think about the Supreme Court ruling when they chose not to dismiss the ban, and I'm not going to say they upheld the ban, but they didn't toss the ban out. If you look at that dissenting opinion, Justice Breyer suggested that if there was a waiver process in here that was not actually objectively being implemented, well then, in fact, this was a Muslim ban. So in my oversight capacity as chair, I want to know what that waiver process looks like. I appreciate that State Department's provided us some data, but when I look at that data, of the tens of thousands of waiver applications, only 5% have been granted. I want to know why 95% were denied. Were 95% of the folks trying to come to the United States for reasons of hardship or national interest, did they present a national security risk? Again, I want to know what happens when that waiver application is sent, into this black box, when it goes from the embassy to Washington, D.C. Who makes the decision? What's that process look like? What authority have our consular officers been given? I think about this in the context of our most important job as members of Congress. It is to not just do oversight, but the people who we work for are our constituents, the people that we represent. And I think about one of my own constituents, Omnia. Omnia is a 2-year-old. And like many families in districts all across this country got stuck in this. And let me share her story. Her mother is an American citizen. She happened to be in Libya when Omnia was born. Her father is a Libyan. She was 7 months pregnant. She went to the consular office and she wanted to come back to the United States for her second child's birth. That 2-year-old was denied a visa. Now, Omnia's mother was told to return to the United States, have her child, and then come back to Libya and let the process take place. I find it hard to fathom that 2-year-old didn't face undue hardship by being separated from her mom. I find it very difficult to fathom that 2-year-old presented a national security risk. And I find it very difficult, given the values that we care about in this country of keeping families together, that it wasn't in that 2-year-old's interest, as well as our national interest, to keep that mother and child together. Well, we intervened, we were able to help out, and we were able to reunite that family. But when I saw them in my office a few months ago, that child continues to have anxiety issues and separation. That isn't who we are as the United States of America. So I've talked to many of my colleagues. They have similar stories to share about their constituents. The number of spouses that are being kept apart, the number of parents who want to see their children, even temporarily, who may be dying, who are not able to come visit their children. The number of children who can't see their parents who may be dying. Again, that isn't who we are. So I think all of us can agree that we have an obligation to keep our country safe. We have an obligation to have a thorough vetting process. But core to who we are is these values of humanity, these values of freedoms. And when you ban entire countries, that really smacks against who we are as the United States of America. So I look forward to the testimony of the witnesses. I expect answers to the questions and data about processes, denials, et cetera, as well as approvals. And again, I look forward to working with you. So thank you. And with that, Madam Chairwoman, I yield back.
Gentleman yields back. I'm now happy to recognize the ranking member of the Subcommittee on Oversight and Investigations, the gentleman from New York, Mr. Zeldin, for his opening statement.
Thank you to the chairs. Thank you for all of our witnesses who will be testifying today. Today's hearing will examine Presidential Proclamation 9645, enhancing vetting capabilities and processes for detecting attempted entry into the United States by terrorists or other public safety threats. I want an immigration process for a country that allows individuals to pursue the American dream legally while also having a process that prioritizes America's national security. We are a generous nation that offers refuge to many seeking asylum or escaping persecution, but we must be mindful that bad actors are also looking to abuse the system. Nearly 1/3 of the FBI's 1,000 domestic terrorist cases involve individuals admitted to the country as refugees. It is important that when allowing an individual to enter the United States, that through documentation and interrogation, we are confident that a person is who they say they are, believe in what they say they believe, and does not pose a terrorist threat to our country. This becomes an increased challenge in cases where sufficient documentation is less available, especially because of the country they are traveling from. When the Supreme Court decided Trump versus Hawaii last year, it found that the president has the authority to exclude certain aliens from the country for national security reasons based on the countries that they came from. The travel restrictions were limited to countries previously identified as posing a national security risk by Congress or prior administrations. DHS conducted a thorough worldwide review and carefully identified 8 countries that contained a high-risk profile and failed to satisfy the minimum information sharing standards to ensure proper vetting. This includes basic information sharing requests by the U.S. government to verify the address or previous residence of a refugee, or more importantly, confirm their association with a known terrorist group in the region. Each country was treated differently based on the circumstances, with issues that ranged from failure to verify basic identity documents to the high risk of terrorism havens in each country. There were exceptions and waivers granted on a case-by-case basis. For example, Iranians are still allowed to seek a non-immigrant student visa or an exchange visitor's visa. Countries such as Chad and Sudan that showed improvement in their vetting process in cooperation with the U.S. were removed from the visa restriction list. These travel restrictions could prevent attacks against individuals expressing an affirmative intent to harm United States citizens. Mohammed Osman lawfully resettled as a refugee with 5 children during the last administration in Tucson, Arizona. Osman stands accused of hiding his membership in the Al-Shabaab terrorist group. There are other examples of terrorists who have lawfully gone through the system and escaped vetting. As was mentioned just last week, the DOJ charged Alexei Saab, a naturalized U.S. citizen, for conducting intelligence gathering in New York in pursuit of terrorist activities on behalf of Hezbollah. Alexei Saab came from Lebanon, a country not on the travel ban list. I would support examining this list on a regular basis to ensure we allow countries that have improved to come off the list, and other countries as necessary to undergo a review to possibly be added. Since January 2017, there have been several revisions to this proclamation. The rollout of the plan needed more careful deliberation and resulted in some unintended consequences. However, the underlying policy was correct. It is difficult to measure the threats we have stopped as a result of this travel ban, but as a matter of national security, it is better to be proactive than reactive. I look forward to hearing from our witnesses about the vetting procedures, why these countries were specifically chosen, and how we can improve the process. I yield back.
The gentleman yields back. I would now like to recognize the chairman and ranking members of the full committee. First, the chairman of the Judiciary Committee, the gentleman from New York, Mr. Nadler, for his opening statement.
Thank you very much. When the Trump administration issued its first version of the Muslim ban in January 2017, it was immediately apparent that it was unconstitutional, discriminatory, and morally reprehensible. The day after the executive order was signed, I, along with my colleague from New York, Representative Velasquez, went to JFK Airport to try to make sure that those who were arriving would have their visas honored. The scene at the airport was chaotic and heartbreaking. Refugees, people with valid visas, and even legal permanent residents were detained for hours and prevented from speaking with their attorneys. But amidst all the confusion, I also observed America at its best. The incredible outpouring of compassion and support for individuals subject to the ban, offered by volunteers from all walks of life, was inspiring. Alongside these volunteers, Representative Velasquez and I helped to secure the release of 2 individuals who were detained by Customs and Border Protection because of the ban. One such individual was Hamid Khalid Darwish, an Iraqi who had been granted a special immigrant visa for risking his life working with American and coalition forces abroad as a translator for 10 years, but was now being ordered to leave the country. What I saw that day at JFK gave me great hope. I did not know that people all over this country would rush to the airports that day to unite against this outrageous policy, or that the courts would so quickly and effectively block what amounted to a xenophobic Muslim ban. When the second version of the ban was also stopped by the courts, the Trump administration went back to the drawing board a third time. Sadly, the inclusion of a phony waiver process, along with the naming of a couple of non-Muslim majority countries, was enough to convince the Supreme Court that this last version of the ban passed constitutional muster. We are now living with the consequences of that fateful decision. Since the Supreme Court's ruling, the ban has had a significant impact on American communities. It has severed support systems and kept families apart. A 2019 Cato Institute analysis found that the ban has prevented more than 9,000 family members of U.S. citizens from entering the country, including more than 5,500 children. The ban provides for a waiver on a case-by-case basis if the Department of State, consular officer, or Customs and Border Protection official determines that 1, denying entry would cause undue hardship to the individual, 2, admission of the individual would not pose a threat to national security or public safety, and 3, admission of the individual would be in the national interest. While this sounds straightforward enough, it is anything but. In his dissent in Trump versus Hawaii, which upheld the third version of the Muslim ban, Justice Breyer noted that, quote, waivers are not being processed in an ordinary way, unquote, and, quote, there is reason to suspect that the proclamation's waiver program is nothing more than a sham, close quote. This skepticism is warranted. Only 5% of adjudicated claims have been approved for a waiver. Moreover, reports from inside the Department of State indicate that the department's internal guidance on the waiver process is inconsistent with its public representations. As we consistently see in media reports, and as we will hear from some of the witnesses today, the cases of far too many individuals languish for months, and some for well more than a year in the black hole known as administrative processing. In that time, U.S. citizens, including children, remain separated from their families with no recourse. The Muslim ban has not made us safer. It has weakened our standing in the world and runs contrary to our country's moral and philosophical foundation. The United States has always been, and must continue to be, a place that welcomes and embraces people of all religions and nationalities. Our country's reputation as a beacon of hope, tolerance, and inclusion for those fleeing persecution, reuniting with their families, or simply seeking a better life has been tarnished by the acts of this administration and by the ongoing implementation of the Muslim ban. It is incumbent upon us here in Congress to call the administration to task and to hold it accountable for its discriminatory policies until they are finally and effectively repealed. I thank our two chairs, Ms. Lofgren and Mr. Berra, for holding this hearing today, and I look forward to hearing from the witnesses. I yield back the balance of my time.
Gentleman yields back. Because of our change in schedule, Ranking Member McCall, Ranking Member Collins, and Chairman Engel were unable to be here, but they will be invited to submit their statements for the record. I would also like to note that Congressman Rose and Congresswoman Judy Chu have joined us here in the audience, and we thank them for their attendance. There will be two panels of witnesses for today's hearing. The first panel includes two government witnesses from the U.S. Customs and Border Protection and State Department. This panel will be followed by a panel of non-governmental witnesses, including a policy expert on the Muslim ban and two individuals who are personally impacted by this policy. I will now introduce the first panel of witnesses. Mr. Edward Ramatowski serves as Deputy Assistant Secretary for Visa Services with the State Department's Bureau of Consular Affairs. As Deputy Assistant Secretary, he oversees the Visa Office in Washington, D.C., 2 domestic processing centers, and operations at over 200 U.S. embassies and consulates abroad. He has previously worked as Special Assistant to the Assistant Secretary of State for Consular Affairs and held leadership posts at the U.S. Embassy in the Bahamas and the consular offices in Mexico, Jamaica, and Colombia. He has also served as an officer in the Office of Andean Affairs, a watch officer in the State Department Operations Center, and on the White House Situation Room staff. Elizabeth Newman is Assistant Secretary of State for Threat Prevention and Security Policy at the Department of Homeland Security's Office of Strategy, Policy, and Plans. Prior to that, she served as Deputy Chief of Staff to the Department of Homeland Security, Secretaries John Kelly and Kirsten Nielsen. She also served under the George W. Bush administration as a domestic counterterrorism and Homeland Security staffer in the White House and worked for the Department of Housing and Urban Development and the Department of Education. Between her positions with the executive branch, she spent many years consulting, during which she focused on homeland and national security issues. And finally, we have Mr. Todd Hoffman, who is the Executive Director of Admissibility and Passenger Programs and U.S. and Customs and Border Protection's Office of Field Operations. Mr. Hoffman has worked for the CBP since 1991 and has served in various capacities, including Area Port Director at Los Angeles International Airport and of the Los Angeles Long Beach Seaport. He's also served as Office of Field Operation Headquarters as Director for the Non-Intrusive Inspection Division and Program Manager for the Anti-Smuggling Division. We welcome all of our distinguished witnesses and we thank them for participating in today's hearing. Now, if you will please rise, I will begin by swearing you in. Please raise your right hand. Do you swear or affirm under penalty of perjury that the testimony you are about to give is true and correct to the best of your knowledge, information, and belief, so help you God? Let the record show that the witnesses have answered in the affirmative and you have been seated. Please note that your full written statements will be made part of the record, and accordingly, we ask that you summarize your testimony in about 5 minutes. To help you stay on time, we have a lighting system, and when you have just 1 minute left, the light will turn from green to yellow. When it's red, your 5 minutes are up, and we'd ask you to please wrap it up. So we will begin. Mr. Ramatowski, if you may begin with your statement.
Thank you. Good morning, Chairwoman Lofgren, Chairman Bera, Chairman Nadler, Vice Chair Jayapal, and ranking members Biggs and Zeldin, and other distinguished members of the committee. I want to thank you for the opportunity to testify today about the Department of State's role in implementing Presidential Proclamation 9645, including vigorous diplomatic engagement with foreign governments to improve U.S. national security, as well as administering exceptions and waivers to the proclamation's travel restrictions. The proclamation and the strides we made in information sharing and border security with many foreign counterparts have been important factors in strengthening the United States immigration system. The Department of Homeland Security leads this process, and the Department of State has worked closely with DHS and other interagency partners and with our embassies and consulates overseas to implement the proclamation in a consistent manner, allowing us to enhance the security of our borders while still facilitating legitimate travel permitted by the proclamation's exceptions and waivers. Our first priority when adjudicating all visa applications, including those covered by the proclamation, is to ensure that applicants pose no security risk to the United States. Our second priority is to ensure that consular officers apply the proclamation in a consistent manner and that applicants who may be subject to the proclamation are informed about its requirements. Our third priority has been to improve the waiver process to reduce the often lengthy security vetting delays by replacing a time and resource-intensive interagency manual review process with an automated system. If an applicant does not fall into an exception category, but is otherwise eligible for a visa apart from the proclamation, a consular officer will automatically consider that applicant for a waiver based upon the criteria set forth in the proclamation. These criteria are: issuance of the visa is in the national interest, denial of the visa would cause the applicant undue hardship, and the applicant poses no national security or public safety threat to the United States. The applicant need not prepare any separate application for a waiver or pay any additional fee. The necessary information is gathered by the consular officer at the time of the visa application. The department worked closely with the White House and other agencies on the creation of exceptions and waivers of the proclamation's entry restrictions. We sought authority for the consular officers to make these decisions because they are in direct contact with the applicants and are best placed to assess each applicant's personal circumstances and purpose of travel under the proclamation. The required interagency security review is, out of necessity, conducted back in Washington with the assistance of vetting partners from other agencies who have access to relevant national security and intelligence information. The results of that are then provided back to the consular officers for final action. As noted, the security vetting requirement has been the longest part of the waiver process. In July 2019, the department and partner agencies initiated a pre-interview enhanced automated screening and vetting process for proclamation cases after first ensuring that the new process was just as secure as the manual system it replaced. As a result of this vetting refinement, as of September 14th of 2019, the department has issued more than 7,600 visas pursuant to a waiver of the proclamation. In addition to that, more than 5,000 visas were issued to nationals of the proclamation countries under exceptions, and 8,830 were not covered by the proclamation. We anticipate completing a majority of the waiver clearances that are still ongoing, but which still require some degree of manual review over the next 6 months. This new system is intended to increase significantly the speed and efficiency of the vetting process for both currently pending and future proclamation subject applications, while also enhancing the quality of our security reviews. Finally, I would like to take the opportunity to invite you to visit one of our consular sections overseas to see how our dedicated professional team works to keep America safe and secure while facilitating legitimate travel. Thank you.
Thank you. We will now recognize Ms. Newman for her 5-minute statement.
Madam Chairwoman Lofgren, Chairman Bera, Ranking Member Biggs, Ranking Member Zeldin, and Full Committee Chair, Chairman Nadler. Distinguished members of the subcommittees, thank you for having us here today. This month, we observe the 18th anniversary of the attacks of 9/11, and since its inception, DHS has been focused on combating terrorist travel. In those early years after 9/11, I served on the Domestic Counterterrorism Directorate at the White House and worked on the policies we needed to prevent acts of terrorism, including breaking down the wall between law enforcement and intelligence information and establishing the foundational policies of our information sharing arrangements used today. Currently, I serve at DHS headquarters as the Assistant Secretary for Threat Prevention and Security. I oversee 8 offices of dedicated men and women that address screening and vetting, with a particular emphasis on combating terrorist travel, countering terrorist, hostile nation states, and transnational criminal organizations, the Visa Waiver Program, the Real ID Program, countering unmanned aerial systems, and the Office of Targeted Violence and Terrorism Prevention. Last Friday, we released the department's first strategic framework for countering terrorism and targeted violence. It states that foreign-based terrorism remains a priority for DHS and describes how the department, along with our federal agency partners, has used a multi-tiered approach to protection. This approach pushes our borders outward and creates multi-layered sets of defenses. The U.S. government has, by the grace of God, been successful in preventing another 9/11. But you only need look at the FBI's caseload or recent arrests to know we still have more to do to strengthen our screening and vetting capabilities. Goal 2 of the strategic framework is to prevent terrorists and other hostile actors from entering the United States and deny them the opportunity to exploit the nation's trade, immigration, and domestic and international travel systems. Foreign partner information is critical to accomplishing this goal. Our screening and vetting programs start with information provided by foreign governments in the form of a passport, as well as other data provided by the traveler throughout the travel continuum. Our responsibilities under Executive Order 13780 and Proclamation 9645 are to establish identity management and information sharing criteria, regularly review every country's performance against those criteria, and ensure risks stemming from the deficiencies identified during the review are mitigated. DHS's implementation of this responsibility is similar to the improvements it's made to the Visa Waiver Program. The Visa Waiver Program Improvement Act of 2015 expressly required DHS to look at the quality of foreign government information sharing and border security, and earlier VWP legislation required modern e-passports and lost and stolen passport reporting. The identity management and threat information sharing criteria DHS developed pursuant to the executive order are also widely seen as international norms and are reflected in UN Security Council resolutions like 2396 and ICAO standards and best practices. The USG explained the criteria and its expectations for how they are implemented through our official diplomatic channels, and today countries from every continent are complying with the criteria. DHS uses interagency approved processes. The regular review has also helped. I apologize. DHS uses an interagency approved process to review every foreign government's performance on implementing the criteria. This process leverages authoritative data, the practical experience of USG personnel who work with the government, and intelligence data to get a comprehensive perspective on what the country is sharing and the relative risk its citizens pose to the U.S. Through this routine review, DHS and state have seen improved cooperation with foreign governments. For example, one country reinstituted a dormant program to help identify convicted criminals. Another country helped the U.S. revoke the visas of its most notorious criminals, including one that was en route to the United States, and a third convicted 7 individuals committing fraud in their visa applications. The regular review has also helped the U.S. promote better compliance with international standards and best practices. 3 countries have adopted more secure e-passports, 2 countries obtained access to Interpol databases for the first time, and 8 countries began reporting lost and stolen passports to Interpol for the first time or improved the regularity of that reporting. These steps improved U.S. and international security, and the travel restrictions that remain in place under Proclamation 9645 are there to mitigate the risks posed by foreign governments that have proven unwilling or unable to adhere to the criteria. Nonetheless, travel restrictions under 212F of the INA are conditional and will remain in place only as long as necessary to reduce national security risk. When a foreign government addresses these identified deficiencies, the Secretary may recommend rescinding or adjusting the travel restrictions. For example, the country of Chad made improvements and the U.S. resumed normal visa issuance in April 2018. By establishing identity management and information sharing criteria and holding foreign governments accountable for adhering to them, DHS is modernizing the international travel system from one that relies solely on analog passport data to one that takes a more dynamic view of identity and risk. Thank you.
Thank you very much, and we'll turn to our final witness, Mr. Hoffman, for your testimony.
Thank you. Chairman Nadler, Chairwoman Lofgren, Chairman Bera, and Ranking Members Zeldin and Biggs, and distinguished committee members, thank you for the opportunity to testify before you today. The focus of my testimony will be on the action CBP took for a 1-week period 2.5 years ago to comply with Executive Order 13769. Upon receiving the executive order on January 27, 2017, CBP took immediate steps to prepare policy guidance that complied with the order. CBP worked very closely with the Department of State and communicated with the air carrier and travel industry on multiple occasions to advise them of the actions we took to comply with the order. At our ports of entry, in-scope travelers from the subject countries were allowed to withdraw their applications for admission, while other travelers who qualified for exemptions were processed for national interest waivers. CBP took immediate action as necessary to modify our policies to comply with the various court orders affecting implementation of the order. CBP field leadership and frontline officers performed admirably to implement the order and ensured all affected travelers were treated with dignity and respect. Although CBP played a prominent role to comply with the executive order for a 1-week period 2.5 years ago, the proclamation currently in effect is focused at the time travelers apply for a visa, which eliminated impact at our ports of entry. Thank you, and I look forward to your questions.
Thank you very much for your testimony. We will now proceed to questions by members of the committees and who will have the opportunity to question these witnesses for 5 minutes, and I will begin with myself. Mr. Ramatowski, we know that the Department of State is able to post a number of waivers that have been approved and denied as part of the ban. Looking at those numbers, around 5% are approved for a waiver, as you say. But the data we received, we being the Judiciary and Foreign Affairs Committee in July, said that the State Department can't track and doesn't know the number of individuals currently under review for a waiver under the ban. Is that correct?
Madam Chairwoman, let me first correct the record in terms of the number of waivers that have been issued. As I said in my testimony, we've issued more than 7,600 waivers, which is considerably more than just 2 months ago. That is due to the change in the security vetting process, which makes a significant difference in the time it takes.
I appreciate that updating. Can you tell us about, is it true that you can't track or know how many are pending?
We definitely do know how many waivers are, waiver cases are pending through the system, but that number is changing daily as...
Okay, so the report to the committees was inaccurate in July.
No, it reflected what we knew at the
time? All right, so it's changed since then.
Yes, it has.
It's my understanding, really, from feedback we've received from constituents, that there's really no formal process to apply for a waiver. You're saying they're all referred, but it looks like some consular officers accept supplementary materials, others do not. There doesn't appear to be a consistent and coherent policy. Is that currently the case?
No, that's not correct, Madam Chairwoman. The process had to be created rapidly when the initial executive orders were issued. And at that point, instructions had to be sent to the field. Officers who did not have familiarity with the process had to be briefed on what the provisions of the proclamation were and all of the different requirements that they should look for. Our office...
Can I just interrupt? Because you just said what the provisions of the application were. Is there an application process? Because that's news to me.
No, what I said was the provision of the proclamation, 9645.
I misheard you then. Can you, okay, we have a gentleman here I met earlier this morning who met his fiancée getting their PhD at UCLA. She was born in Iran, but she's a permanent resident of Norway, right? This is his fiancée. They've waited for several years. There's no application. They can't get any information. Is there a way to apply for this person who's now a resident of Norway and wants to come find her fiancé and have their wedding here?
Yes, of course. As I mentioned in the testimony, the consular officer will consider a waiver application with every visa application. It's an automatic process. There would be no sense.
So there's no application, though.
The consular officer gathers the needed information for the waiver review at the time of the visa application. Our visa application asks about such things as purpose of travel, the type of visa that the individual is seeking, and so forth. If the consular officer needs additional information, they have the applicant right there to ask for that additional information. If that information isn't available at that time, the consular officer can allow the applicant to obtain whatever information they're seeking.
But this is all discretionary. I'll just say this, and all of us want our country to be safe. There's no exception. Every single member of this committee and this audience wants our country to be safe. However, some of the examples that have been given here today, a terrorist from Lebanon, well, Lebanon isn't on the list. The people who attacked us on 9/11, they were from Saudi Arabia. They're not on this list. So I'm just struck how this is essentially an irrational process. I mean, Venezuela is on the list, but only for government officials. No one has been subject to the ban from Venezuela. North Korea, there have been some 57 waivers granted from North Korea. Russia has attacked us in the last election. They're not on the list. So it seems to me singling out these countries whose residents are primarily Muslims as a basis for assessing threat is essentially irrational. What we want to do is to make sure that anybody who's coming from any country doesn't pose a threat, and not really make that on the basis of where you were born or what your religion is. I mean, how a 2-year-old would pose a threat is a mystery to us. And it's very difficult to find these out. And I'm wondering if we can't come up with a process that keeps us safe without causing so much harm to American citizens who have family members who were born in one of the countries on these lists. But I see my time has expired. I want to set a good example for the rest of the hearing. So I will now recognize Mr. Biggs for his questions.
Thank you, Madam Chair. Mr. Ramatowski, the way I understand it is when someone applies for a visa from one of these countries, they are automatically reviewed to determine whether they qualify for a waiver. Is that accurate?
Yes, that's correct, sir.
So nobody's going without they don't need a new application because they're all getting reviewed already.
Yes, that's correct. It would make no sense to apply for a visa and then say you don't want a waiver.
Right. So I'm looking back to the 2015 law that some on this committee, certainly on the other side of the aisle, voted for. And it listed in there two nations, Iraq and Syria, would be effectively have a travel ban on them, right? Mr. Ramataksky, you familiar with that?
From the
The 2015 INA.
Yeah.
Yes, right.
Yes, that's correct.
And then DHS Secretary Jay Johnson came in and added several countries to the list, right? I mean, so you ended up with, on that list that was under the Obama administration, was Iraq, Iran, Syria, Yemen, Libya, Somalia, and Sudan, right?
That's correct.
Yeah. And somehow, when President Trump issued his, it suddenly became outrageous policy, xenophobic Muslim ban with a phony waiver process, and contrary to our moral and philosophical foundation. That's what I heard from the chairman of the Judiciary Committee earlier today, and yet the Trump administration didn't just pull these names of these nations out of its hat. It was using the same countries basically as the previous administration, with the addition of North Korea and Venezuela. So it's interesting to me to hear this kind of inflammatory language being used. So does the immigrant visa application change for any of these countries vis-a-vis any other country in the world? Mr. Romatowski.
The basic immigrant visa application has not changed, no, sir.
Does it ask about religion on that application?
It does not.
Does the non-immigrant visa application ask about, in any way, about the religion? So does the interviewer ask about religion?
No, they don't.
Does religion play a role in determinations made during the adjudication process?
No, sir.
And Ms. Neumann, is it Neumann or Newman?
Newman.
Okay. There's this famous microphone spelled just like that that we pronounce Neumann. But anyway, have there been countries that provide information such as that is requested but from which the U.S. cannot trust the information? So the U.S. asks for information from some of these nations, but we just can't rely on it.
Sure. I think we face this challenge in a variety of contexts, not just in this effort, but in all of our screening and vetting efforts. We seek the best information possible, but for example, when we're sharing terrorist watch list data, we're not going to accept certain countries' watch lists because we know that they put political dissidents on that list. So you have to evaluate country by country to determine the efficacy of their information.
Can you give us maybe some of the countries and expand on the reasons that you don't accept their information?
I think I would give as one example North Korea, who's currently not participating or cooperating with us on any of the criteria, the information sharing or identity management criteria. One of those criteria is to share your passport exemplars. That means you're giving us a sample of your passport. We need that to be able to detect fraud, and so that you have experts and labs that can figure out how somebody might tamper with it, what's the real thing versus what a fraudulent passport. If we don't have that, it becomes very difficult for our officers to determine whether a passport is real or not. North Korea does not share their exemplars with us. They have chosen not to cooperate with any of the requests associated with our identity management and information sharing criteria.
Thank you. Mr. Hoffman, how's the mission of the U.S. Department of Homeland Security benefited by the executive orders and subsequent proclamation, in particular CBP?
From my point of view, sir, essentially the work done on the second Executive Order 13780, a lot of the work done under Section 5 made significant improvements to the vetting process.
So, thank you. I'm going to go back to Mr. Romatowski. Are there individuals who are denied visas based on national security concerns using the new enhanced automated security screening who would not have been denied under the previous manual screening process, to your knowledge?
I'm sorry, Congressman, could you repeat your question? You're saying under the new process that we've just introduced versus the old manual screening process?
Yes.
Those two are identical. We don't believe there's any delta between the two, and so the new system is just as secure and much faster.
Thank you.
Gentleman yields back. I turn now to Chairman Bera for his 5 minutes.
Thank you, Madam Chairwoman. Mr. Ramatowski, you're the Deputy Assistant Secretary for Visa Services at State Department, and if there were one person at State Department who would know how the waiver process for the proclamation operates and how state interfaces with DHS to vet policy, that would be you. Is that correct?
Yes, sir.
Great. So a couple questions. And you know, I have had the opportunity to visit our consular officers abroad in multiple countries, as well as going to FSI to see them train. And you know, you see these young men and women who represent and serve our country every day, and the training they go through, the language training, the simulations, et cetera. And you know, I know these are men and women who are doing the best job possible to protect our country, but also represent the values of our country, both here and abroad. So you know, this is not a reflection of the work that they're doing. The proclamation states that consular officers have the discretion to grant waivers. Is that correct?
That's correct, sir.
Do you believe they have had the sole discretion since the proclamation was issued?
Yes, I do.
And who makes the final yes-no decision about whether or not someone receives a waiver?
The waiver process, Mr. Chairman, is based on three review prongs, so to speak. The consular officer makes the decision on the first two,
Okay.
which is national interest and undue hardship. The consular officer is unable to make independently the third decision without referring the case back to Washington, because the security review has to take place back here.
And who in Washington makes that final determination?
Well, the final determination is not made in Washington on that case. What Washington does with partner agencies and so forth is conduct a deep dive, intensive review of each case, and then any results, derogatory results from that review will be provided back to the consular officer.
And, you know, again, I would imagine that for any visa applicant or, let's say coming from India or any other country, we would have a security vetting process, would we not?
That's correct, sir.
Does that vetting process and does that consular agent in the non-travel ban countries have the ability to clear that security clearance?
No, all the clearances are sent back to Washington. It's called a security advisory opinion. And if our initial automated checks at the time of the visa application reflect any potential derogatory, a red light, so to speak, the case is sent back to Washington for a detailed interagency review. Now, up until this new modernized system was introduced, the proclamation cases got an extra deep dive, intensive manual review that other cases from other countries did not require. And that accounts for the lengthy delays at the beginning in the waiver process.
With the new automated process, is it your sense that that delay and, you know, you'll close the gap between the 7 countries that are part of the Muslim ban versus the non-travel ban countries?
Yes, it is making a very significant difference. The information that the committee cited earlier from our earlier letters, about 5%, the number is considerably higher than that now.
Would you be able to provide Chairwoman Lofgren and myself and the 2 committees the latest updated numbers?
Yes, I gave them in my testimony, but we can certainly provide a chart to the committee.
Great, on an ongoing basis. You know, in addition, you know, when we're thinking about this, and again, you know, no way, we want to have a thorough vetting process. We want to keep the bad guys out of the country. But those folks, meaning harm, don't just come from 7 countries. They could come from anywhere. So we want an objective process. We want to make sure our consular agents have thorough guidance and so forth, and have that ability to make those decisions. You know, when it goes to the visa office to, you know, again, in that process, who makes the final decision, you know, to grant the waiver or not? Or is it now all automated and there's no?
No, it is not all automated. So again, Mr. Chairman, an applicant will apply for the visa. Step 1 is for the consular officer to evaluate all other aspects of the immigration law. Is that individual qualified for the visa or immigration benefit they're seeking. If they're not, then the waiver and proclamation is not considered. But if they are, then the consular officer begins the process that I outlined. First, they review to see, is this case one of the exceptions that the president permitted in his proclamation? If it's not an exception, then the consular officer considers the waiver grounds and will look at national interest and undue hardship, which, quite frankly, the consular officer is in the best position to decide that.
I know I'm out of time, and if I could just ask for one piece of information as well. Of the denials, is it possible to provide us the information for why these visa waivers were denied?
We have general information on that, Mr. Chairman. Unfortunately, our visa system was not designed with this waiver process in mind. We are operating on legacy systems that were designed many years ago. And so most of the consular officer information is included in narratives in the database. So it's somewhat difficult to...
To the extent possible, could you provide us the best information?
Certainly, we'll provide whatever we possibly can.
Thank you.
Thank you.
The gentleman's time has expired. We now turn to the gentleman from New York, Mr. Zeldin.
Thank you to the chairs. And as Mr. Biggs pointed out, the list of countries is a list born out of the past administrations. The last administration, when they were coming before Congress talking about security concerns that they had with these nations, we all, Republicans, Democrats, conservatives, liberals, were all working together with the administration with their national security concerns that they wanted help with addressing, identifying predominantly these nations. We have currently 7 countries on the list. 2 aren't even majority Muslim countries. 92% of the world's Muslim population is not included on this list. Of the top 10 majority Muslim nations in the world, top 10, only 2 of them are included on this list. And there are concerns with these individual countries that leads to the current administration coming before Congress, just like the last administration did, because the countries still have issues. Syria is still in a very bad place. Syria, you can argue, is in a worse place than it was during the last administration. Totally destabilized. Our great employees working hard to execute vetting for our country don't have a partner on the other side to contact your partner in the Syrian government or the Yemenis government. Say, I have an applicant, I have some documentation I want to verify, I want to make sure it's accurate, or I have a question, can you assist? There are a lot of countries all around the world where we have that ability. The documentation is verifiable, but we have applicants coming from certain countries where the country has been completely destabilized to the point where we don't have that willing partner and the documentation can't make up for that extra vetting that's now required. Yemen was overthrown by the Houthis. As I mentioned, with attacking this current list, North Korea and Venezuela aren't even majority Muslim. So I think it is really important that this hearing takes place. I really think it's really important that you're here for the discussion to be had for Americans to understand that vetting component. And these countries that are on the list are countries that have been significantly destabilized by factors that impact our ability to vet the applicants. So if you can walk us through that vetting component as it relates to documentation, as it relates to interrogation, and how do you make up for a lack of documentation? How do you make up for a lack of having a willing partner from that country in order to ensure that someone is safe? Can someone speak to that vetting piece as far as making up for a lack of documentation to properly vet someone?
I'm happy to take that, sir. In the security realm, we deal in shades of risk. Some of the members have spoken to the fact that we have individuals that have made it into the country and carried out terrorist attacks that were not from those 7 countries. We are very cognizant of that, and the administration has taken steps building on groundwork that had been laid by the Obama administration to strengthen our vetting system. We've made a lot of progress, and the vetting apparatus, as my colleagues have testified to, focuses on the being able to identify the individual, and we do that biographically, we try to do that biometrically, and making sure that the person presenting is who they say they are, and then comparing that against any information we can get, whether that's our information or foreign government's information. The challenge with these 7 countries, which we have been reviewing, and while initially, yes, those 7 countries were based on a 2015 law and a recognition that we were concerned about those countries' stability and government, we have since implemented a very robust process of identifying the criteria we're looking for countries to adhere to in order to ensure that we are comfortable that they practice good identity management and they share information with us that will help us detect whether that individual trying to come here is a child sexual predator or a terrorist. There is no bulletproof solution. We are inviting risk anytime we allow somebody into our country. That's a risk that we as a country have said is one that we're willing to bear because that is the nature and the foundation of our country, is to invite others to join us. But we want to do it with risk in mind. We know that terrorists have intent to attack our country, and we believe that this effort under Proclamation 9645 it has enhanced our security because we're now talking about what otherwise is kind of boring: identity management standards, information sharing protocols. No diplomat gets excited about going to talk to their counterparts like, hey, you really need to do better in checking your Interpol database. But because we've paid attention to this and focused on it and said, no, we got to get the basics right, we're now enhancing standards across the globe.
Thank you.
Gentleman's time has expired. I would note that there's been several references to the Visa Waiver Program Improvement and Terrorist Travel Prevention Act of 2015. For the record, that did not deny visas. It just required those who could be subject to the Visa Waiver Program to apply in person instead. And it included not just nationals, but people who had traveled to an area where ISIS was an active military. And I would ask unanimous consent to include a copy of the Visa Waiver Program Improvement and Terrorist Travel Prevention Act of 2015, noting that it included Iran, Iraq, Sudan, and Syria, which is different than the list on the order at question here today. I would...
Madam Chair, may I?
Of course. Do you object to including the copy of the act?
Well, here's the thing. I don't object to. I object to the comments surrounding the act. So you've made comments. No problem with the act coming in as part of the record, and your comments certainly are going to be part of the record. But there's not an appropriate way, quite frankly, for me to respond to those, and I think that's unfortunate.
Noted for the record, with unanimous consent, the act is made a part of the record, and we will now turn to the chairman of the Judiciary Committee, Mr. Nadler, for his 5 minutes.
Thank you, Madam Chairman. Ms. Newman, you stated that countries are on the ban because we cannot trust the information on their nationals. And I don't really understand something about that. Do we trust the information from Russia?
I believe what I said respectfully is that the way in which they manage their identity management and the types of information they share, they in many cases don't share with us, brings a certain amount of risk to
Is that true of Russia also? Do they share everything with us?
With respect to specific countries, I would have to move into a closed session and probably classified session because
You cannot say yes to that question.
As it pertains to Proclamation 9645, I'm not at liberty in an open session to talk about particular countries.
How about China? Do we trust the information from China?
with respect to Proclamation 9645, particular
Now,
countries.
China and Russia are not predominantly Muslim countries, are they?
The Department of Homeland Security does not assess that, but
Oh, come on.
I would refer to.
China and Russia are not predominantly Muslim countries. I'll take notice of that fact.
Fair, fair.
You can look it up in the Encyclopedia Britannica or Wikipedia or any place else. Now I think I understand. Mr. Hoffman, I wanted to discuss the initial announcement of the Trump administration's Muslim ban and the chaos that ensued at our airports. You were in the leadership of CBP in January 2017, correct?
That's correct, sir.
Were you or anyone else in CBP shown a draft of the first Muslim ban, Executive Order 13769, before it was issued on January 27, 2017?
No, sir.
Were you a part of any discussions around an executive order that would bar Muslims from entering the United States?
I was not.
In fact, it sounds like next to no one was consulted. According to the Inspector General, quote, DHS and its components had no opportunity to provide expert input in drafting the EO, unquote. Even worse, the IG report revealed that 2 days before the ban was signed, then acting CBP Commissioner McAleenan actually received a detailed summary from congressional staff of what would be in the executive order rather than receiving this information from the White House. Was any of this information, either the summary shown to the commissioner, drafts of the executive order shared with DHS leadership, or the extensive media reporting that an order was coming, shared with frontline CBP staff?
Can you clarify your question, sir?
Was any of this information that I just listed, either the summary shown to the commissioner, drafts of the executive order that was shared with DHS leadership, or the extensive media reporting that an order was coming, was any of this shared with frontline CBP staff?
Not to my knowledge, sir. I'll defer to the Inspector General's
So
report.
CBP was unable to make any preparations for an eventual executive order, is that correct?
To my knowledge, that's correct.
Now, the executive order was signed on Friday, January 27th at 4:43 p.m. in the afternoon. Was anyone at CBP leadership given any advanced warning that the order would be signed that day or that it would need to be implemented immediately?
Not to my knowledge.
When a major policy change that implicates CBP operations like this is announced or rolled out, is it unusual for CBP to be kept in the dark in this way?
It's atypical, usually, when something is going to be formulated policy, that we would give some feedback regarding
Thank
scope and intent.
So it's unusual. What usually happens when a new policy is announced that impacts CBP operations? Are the components consulted? Do they have an opportunity to provide feedback?
What I can tell you, sir, is 1 month later, when the second executive order, 13780, we had a comprehensive rollout strategy. We worked closely with the department.
And that's the normal, and prior to that, when you had new strategies, that would be the normal procedure.
What I could say, sir, is we were poised for an orderly rollout on the second executive order.
Thank you. Now, with how little input your agency had in the first iteration of the ban, and the fact that the executive order went into place immediately, is it surprising, given those two facts, that its implementation caused mass confusion and chaos at ports of entry?
I wouldn't say it caused chaos. It was a challenging implementation because it was in a real-time environment. It applied to real travelers as they were actually in their travel cycle. But I don't believe there was any chaos within our facilities.
That there was confusion?
I wouldn't say there was confusion either.
Then you wouldn't say the obvious. Given the lack of interagency consultation and planning, was there any way this chaos could have been avoided?
Again,
this confusion?
sir, I would not call it chaos. Within our facilities, there was no chaos. You have to remember, we get 1.1 million travelers a day. This applied to 200 to 300 on any given day. So although this was significant work for us at the time, again, in our entire mission, this was a small sample.
As my time is expiring, I'll simply say that I personally observed the chaos at JFK.
Gentleman's
Yield back.
time has expired. The gentlelady from Arizona is recognized for 5 minutes.
Thank you, Madam Chairman. I'm perplexed by the title of this hearing. The title is Oversight of the Trump Administration's Muslim Ban. And as has been said a couple times here, the people that come from the countries that are on this travel ban only make up 8% of the Muslim population in the world. So if the intent of the Trump administration, as my Democrat colleagues contend, is to ban Muslims, They're doing a pretty darn poor job of it because 92% are not in the ban. And so all I can think of is that we are here again, once again, week after week, multiple times a week, bashing the Trump administration to try to influence the 2020 election. This is all that is happening here in this committee, day after day, week after week, from the party of impeachment. They want to impeach President Trump, they want to impeach Kavanaugh, they want to impeach anybody and everybody that seems to be conservative, in my opinion. So I have a question for Ms. Newman. Ms. Newman, how is the mission of the U.S. Department of Homeland Security, how has it benefited by the executive orders and subsequent proclamation?
Thank you for your question, Congresswoman. I noted in my oral testimony that the Secretary highlighted in his DHS's recently released strategic framework for countering terrorism and targeted violence that foreign partnerships, including our information sharing relationships, are really critical to countering terrorists. However, the USG regularly prioritizes its diplomatic engagement on information sharing against other priorities, and this is a good thing to have a little competition among the U.S. agencies. But this effort has allowed the Department of Homeland Security to bring highlighting to our colleagues at the State Department, embassies, and foreign partners that sharing information for purposes of border security, if you will, is very critical to ensuring all of our safety. And it has allowed us within the department to better prioritize our technical assistance. I think one of the things that might be getting lost as we're talking about the program, we're able to use this tool, the assessment, to identify the deficiencies and then follow along with engagement. We spend most of our effort on engaging countries and encouraging them to strengthen their capabilities, to make those connections to Interpol, to report lost and stolen passports, to make, in some cases, it's a long-term investment in advancing some of their systems. So by having this systematic, routine, deliberative, objective review process, we're better able to prioritize our own technical assistance and then work with the Department of State on foreign assistance.
Thank you. And does any of the other witnesses want to comment how you think this proclamation and executive order has actually improved our national security?
Thank you. Yes, as I mentioned earlier, I would add it's my understanding that a lot of the work performed under the second executive order, 13780, Section 5 work in particular, made significant enhancements to our overall vetting and having access to real-time classified data, and having real-time access for ESTA applications. And also, it's my understanding that the work led to the creation of the National Vetting Center as well. Again, providing a clearinghouse for real-time classified information to ensure all the adjudicators have access to that information so they can make informed decisions when they do this critical vetting work.
Thank you. And I'll yield back my time. Thank you.
Gentlelady yields back. The gentlelady from Washington, Ms. Jayapal, is recognized for 5 minutes.
Thank you, Madam Chair. I did just want to say, in reference to the chaos at the airports, even while it may not have felt that way to CBP, I can tell you at our airport, I was one of the first members to go to the SeaTac airport, and it was absolute chaos, including partly because we had hundreds of people who were so distressed by what they were seeing and people who were being turned away. We were able to, with the Port Commission's help, with the ACLU and pro bono attorneys, we were able to stop a plane that had some people that were being incorrectly turned away. We were also able to get some people back, but it was absolute chaos, and the human impact, I think, was devastating for green card holders and refugees and others with lawful status. I wanted to just go to this question. My colleague from Arizona said 92% of Muslims are not in the ban, therefore it's essentially not discriminatory. I want to make it clear to everyone that not everyone in the discriminated class has to be discriminated against in order for something to be discriminatory. And so let's just talk about the 8 original countries. I understand that Chad is not there anymore, but the 8 original countries, 6 of the 8 are Muslim majority countries, and the 2 that are not, Venezuela and North Korea, have very different waiver rates. And this is the point I want to go to. The Supreme Court upheld Trump's 3rd iteration of the Muslim ban, largely dependent on the waiver position that was supposedly going to keep the ban from being a blanket ban on Muslims. So, Mr. Ramatowski, there are 3 factors that you use to evaluate someone for a waiver, correct? The applicant would suffer undue hardship if denied, admission to the U.S. would not pose a national security threat, and their admission to the U.S. would be in the national interest, correct?
That's correct.
And there isn't a process for an individual to affirmatively apply for a waiver and provide documentation on these 3 factors, correct?
That's part of the visa application process.
So the answer is no, there isn't an affirmative way for an individual to address these. And according to the most recent State Department reporting on the Muslim ban, the State Department has ruled on nearly 38,000 applications between December 8th, 2017 and October 31st, 2018, correct? That's from your report.
That's correct.
Okay. And according to that same report, the State Department has granted waivers in 5.1% of cases, correct?
At that time, that's correct.
Okay. That's on page 3 of the State Department's report. And among Iranians, the approval rate for a waiver is 1.3%, correct?
At that time,
Okay. And as of March 2019, the approval rate for North Koreans was 72%, correct?
yes, Congressman.
And in terms of Venezuelans, 0 Venezuelans have been subjected to the ban period, so they wouldn't have to be considered for a waiver, correct?
That's right. It's only select government officials that are covered.
Okay, so overall, the State Department has granted just 5.1% of waivers, according to the statistics posted on your website. Yet among the only 2 non-Muslim majority countries subject to the ban, the waiver approval rate is 72% or not applicable because no Venezuelan has been subject to the ban. Meanwhile, the waiver grant rate for someone from Iran is 1.3%, Syria 5.4%, Libya 7%. So by definition, Muslim majority countries are being discriminated against unless you believe that all of the people in those countries somehow deserve that kind of a very, very low waiver approval rating.
Congresswoman, as I mentioned in my testimony, we have significantly updated data on this. The report that you're quoting from is almost a year old, if I'm not mistaken.
If I can just interrupt you, I would love to see that data. It is supposed to have been posted already. We went to what was the most recent data that we have, which is December 8th, 2017 to March 31st, 2019. So it's not a year old, but it is old, and we should have an updated report. It is not on the website. I would love it if you would provide me with statistics that are different. Are you saying that the statistics in the recent report are significantly different than what I've quoted you?
Yes, they are. As I mentioned, 7,600, more than 7,600 waivers have been granted, which is more than double what the total was at that time.
And what's the total number?
The total number of waivers, over 7,600.
The total number of applicants from these countries. You can't look at just the number of waivers. You have to look at how many people applied from those countries. Just saying it's doubled doesn't make any sense if you've also doubled or tripled the number of total applications.
Right. So I have some data on that. There's approximately 31,334 refusals up to September 14th, 2019. We have data by country if you want to go down through that. And we have information on the number of waivers issued per country if you'd like to go through that. For example, waiver issuances for Yemeni citizens amount to 4,031. There were 7,011 cases.
It's impossible for me to look at. I would love to have those numbers in hand, because as of this morning, that report was not posted. So I would love to receive that information so I can calculate the percentages myself and really be aware of exactly how this works and make sure that this is not targeting Muslim Americans and their
The
families.
gentlelady's time has expired. We'll ask the witness to provide this information to
We
the
will.
committee. Thank you. The gentleman from Pennsylvania, Mr. Reishaller, is recognized.
Thank you, Madam Chair. I would yield to my friend and colleague from Arizona.
Gentleman yields.
Thank you. I appreciate the gentleman yielding some time. So I can't let this go too much, but as we've tried to adhere to the 5-minute rule, I mean, this is almost inconsequential in some respects, I guess, except for that it is a rule. There's not been one member across the aisle who has stopped their 5 minutes on time. And it isn't just that they're not asking a question and we're going over time to allow a witness to respond. It's that actually they're actually making comments, sometimes as much as a minute and 15 seconds beyond the time. That's interesting to me. And I'm just pointing it out for effect because that's the way this has been. So I want to ask about, someone said, well, how about China? Why aren't they on this list? That was the implication. So my question to you, Ms. Newman, is when we start talking about China and Russia, can you tell us, maybe you can't in this non-classified setting, but can you tell us what do they provide you in response to your information sharing requests as you vet?
Thank you for the question. I cannot talk about specifics, but if you'll allow me to explain the process that we go through, I think that might help answer the roundabout in a roundabout way. We are required to continually monitor the country's capabilities. So on a 180-day cycle, we are working with our partners at state to request information from all countries across the globe about their handling or their meeting of the criteria, and we've talked about those already. We have a set of information sharing criteria, a set of identity management criteria, and then a national security risk picture that comes from the intelligence community. Those are all identified public information in the proclamation. When we go through the process of updating how people are doing, we're asking questions like, did we see people reporting or see the country reporting lost and stolen passport data to Interpol? So we have Post at Embassy is reporting back to us on the status of their country's adherence to those criteria. And then we're collecting information from operators, from Interpol itself, or how our Customs and Border Protection officials are seeing certain trends, perhaps fraudulent passport trends or other crime trends. We take all of that and we assess against a pretty rigorous rubric, and we'd be happy in a closed setting to brief on that rubric. And then on the other side of that, you have scores of how a country is doing in meeting those criteria. To talk about an individual country, we would need to be in a classified setting.
So, well, it leads one to ask, so under the Obama administration, the DHS secretary, pursuant to the statute that's now been brought into the record, gave a list of countries and did not mention Russia or China. And it makes one wonder, so were they adhering to the processes that the Obama administration felt were appropriate 5 years ago under the Obama administration vis-a-vis where they are today? I mean, has there been any significant change or any necessity for Russia or China to be added since the Obama administration didn't see fit to include them on the list?
Again, I'm going to make my comments agnostic to a
You can make it generic,
country. But at the end of our process, we report to the president, And the Secretary makes recommendations whether any of the countries that are currently facing travel restrictions have so improved that they can be removed from the travel restriction, or if their status has changed in some way. We also report if we've determined that a country poses a significant risk to the United States because of a deficiency. And it is then at that time that the President makes a decision about whether to exercise his 212F capabilities. So we walk through that process every 6 months, and you haven't seen those countries nominated. So I think you can
We can make some
assume
assumptions.
that they are not that deficient. Now, here's what I will tell you. It's 200 countries. Everybody has room to improve. And we are working very hard through a variety of mechanisms, including the visa waiver program, where we are very concerned about foreign terrorist fighter flows coming out of Syria into our European partners, which is why this body passed the 2015 Visa Waiver Improvement Act to make sure all of the tools in our toolkit are applied to this potential challenge. So it is, everybody has room to improve, is how I would answer your question.
Gentleman yields back with 21 minutes over the 5 minutes.
But just
Just a
point of
little
privilege.
lightheartedness
Just a
here.
point of privilege. That was in response to a question asked during my time. And actually
I
asked
am
about
not
a minute and a
complaining.
half before my time was in. So
We are trying to be on time, but without a heavy gavel during this hearing. The gentlelady from Minnesota, Ms. Omar, is recognized for 5 minutes.
Thank you, Chairwoman. Mr. Matowski, you've been with the State Department for 33 years, right?
Over 33 years, yes.
No, wonderful. Has it been typical for more than 100 people to sign dissent memos on a given policy?
That would be atypical, I think.
Atypical. Has it been typical for policy to drive several SOs to publicly resign in protest?
There have been Foreign Service officers who've resigned in the past over various policies. That's true.
In June of 2017, between the second and the third version of the Muslim ban, more than 100 diplomats signed a dissent memo that said, quote, banning travelers from these 7 countries calls back to some of the worst times in our history. Former consular officer Christopher Richards, who resigned in protest of the Muslim ban, said in an op-ed that the consular officers were not able to issue waivers on their own, that they had to get approval from the State Department. Would that be you? Do you give that approval?
No, that's not correct. The consular officers make the decision on the first 2 prongs of the waiver, national interest and undue hardship, and then the interagency security review provides the guidance on the security prong.
So that's not a decision you get to make, or is the White House involved in that decision?
Not at all.
Okay. Sarah Gartner, another former FSO who resigned in protest over the Muslim ban, told CNN that fellow officers, quote, felt pressure to approve as few folks as possible for the waiver. She also said that the Muslim ban had been, quote, reworked and sanitized by layers of bureaucracy with people distracted by the next terrible thing. It can be easy to forget it's even happening. Well, it looks like Congress hasn't forgotten. And Madam Chair, I have assigned testimony from 4 former FSOs that I would like to enter into record.
It's put into the record by unanimous consent.
Thank you. Ambassador John Foley, who quit his post as ambassador to Panama in 2018, said he could no longer represent President Trump and still hold true to the value that make this country great. Among the policies he listed was the Muslim ban. In the end, how many diplomats and consular officers signed the dissent memo protesting the ban?
I don't have an exact number for you, Congresswoman. I know that some did.
Will you be able to get us that number?
I can't guess that number, no.
How do you respond to his claim that the consular officers have to get clear waivers with your office?
I would say, as I said before, that that's not correct. The consular officers make the determination on the first 2 prongs of the waiver, national interest and undue hardship, and the security check, as I testified, is conducted back here in Washington. Now, if a consular officer is...
So you're saying his claim is false?
Which claim? That
Mr.
Washington
Richards.
is making the decisions?
Yes.
Yes, that's not correct.
And how do you respond to Ms. Gartner's claim that the officers are implicitly or explicitly pressured to deny waivers?
We are not implicitly or explicitly pressuring anyone to act in any way contrary to the law.
Okay. And how do you respond to Ambassador Foley's claim, shared by all the people who signed the memo, that the ban is a betrayal of American values?
The ambassador is certainly entitled to his opinion on that. There are many, obviously it's very clear that this policy has many opponents, but fundamentally it's designed to try to keep the United States safe.
And to our other two panelists, was Stephen Miller's role in formulating the 3 reiterations of the Muslim ban? What was his role?
I'm not aware of any role played by Stephen Miller.
And Ms. Newman?
I was not at the department in January. I did not start until late February.
Okay. And what instructions were DHS and state given from the White House as how to implement the Muslim ban?
I wasn't given any instruction from the White House.
Again, ma'am, I was not at the department in January 2017.
The department was not consulted about the first executive order.
The gentlelady's time has
Yield back.
expired. We turn now to the gentleman from North Dakota, Mr. Armstrong.
Thank you, Madam Chair. Mr. Radikowski, sorry. We were talking earlier, and I understand this a little bit. We have 3 car accidents in a week in North Dakota, and we jumped to the highest percentage in the country because we have 750,000 people. So when we're talking about percentages, I guess my first question is, how many people from North Korea actually apply for?
Very few. The total that we have here is 115.
So when we're talking about a 72% waiver rate, we're talking, I'm just going to go to 100 because I don't do math that well, so it'd be like 72 people.
Something like that.
So of all the countries that have granted, or that have gotten granted, who has the fewest that have gotten, what country has the fewest number of waivers granted?
According to the data I have from September 14th of this month, North Korea has 5 waivers and 78 visas issued under an exception to the proclamation. That's the smallest number.
And we're absolutely correct. An entire group does not have to be discriminated against in order for discrimination to occur. I agree with that, but I also agree with correlation. Correlation and causation are not the same thing. I mean, we are talking about this. We refer to it's being referred to constantly as the Muslim ban, but by putting any one of, Indonesia, India, and Pakistan are 13%, 11%, and 11%. I mean, in total of our worldwide Muslim population. So if you were dealing with this in that manner, wouldn't it make more sense? I mean, if that was your ultimate goal, wouldn't it make more sense to have them on the ban? Or have them on the list?
I would defer to Homeland Security
Yeah.
regarding the security.
And that's okay. And I know you can't speak to Ms. Newman to specifics about any country, but these are supposed to be temporary, correct?
Yes, sir.
And as we're evolving and more sharing of information, I mean, we know Chad came off the list, but what do countries have to do to work to get off the list?
We have a rubric, and again, in closed session, we'd be happy to brief you on some aspects of that assesses across a variety of criteria in the broad categories of identity management and information sharing. We would need to see improvements, and we're not looking for a gold standard, which is maybe you look at the standards we use for the visa waiver program as the gold standard. These are kind of minimal capabilities that we're looking for a country to have, so that, again, the purpose is not because of anything other than we need to know that the passport being presented is the individual that it says it is, And we need to know if that individual in their home country has a criminal record or is a known or suspected terrorist. That's kind of what this comes down to, is we need you to tell us more about this person. We need to have a relationship with you in order to be able to have that conversation. And you have to have a certain basic infrastructure to be able to do those tasks.
So would it be fair to say countries who are bad actors in other ways, this is a very specific thing. So even if countries are bad actors in other ways, they can be complying here, correct?
Correct. This is a tailored tool to prevent terrorists and serious criminals from being able to gain entry into our country.
And so, like, when we talk about Iraq, I think one of the things we forget is that we have a relationship with Iraq. For good, bad, or indifferent, we have been in country for well over a decade, and that's one of the reasons where, I mean, so outside of their government interacting, we actually have knowledge base in which to deal with individuals who are applying.
That's correct, and we take into account as we're doing those assessment that kind of relationship that may get us access to information to be able to do those identity checks.
And I would contrast that with somebody like Syria, and everybody's favorite former FBI director actually testified in front of this committee in 2015, and he said, we can only query against that which we have collected. And so if someone has not made a ripple in the pond in Syria on a way that would get their identity or their interests reflected in our databases, we can query our databases until the cows come home. That was his saying, not mine. But nothing will show up because we have no record of that person. You can only query on what you have collected. And with respect to Iraq, this is where it goes into the Iraqi refugees. They have a relationship. So if you don't have any information, we're talking about moving to the Washington, the third prong. I mean, if you don't have any information at all, you cannot have any identifying marks on somebody who's going through this process. What happens next?
For the third prong of the waiver process, the case is brought back to Washington electronically and given an intensive screening by various partner agencies in the law enforcement and intelligence communities. We could brief in more detail in a classified setting, but that's exactly what their responsibility is, to try to see, is there anything under U.S. government holdings that might be derogatory, that might represent a threat?
Thank you.
Gentleman's time has expired. The gentleman from New York, Mr. Aspelay, is recognized for 5 minutes.
Thank you, Madam Chair. I want to go back to January 2017, as stated by colleague Chairman Nadler. He was at JFK Airport. I also was at JFK Airport. Unlike the chairman, who was there with another member of Congress, I deployed to a terminal within JFK where I was the only member of Congress, where three people coming from the Muslim ban countries were being detained. There was a student from NYU, which was being received by one of her professors that did life-saving research at that university that was being detained. There were two other family members of the armed forces that were there waiting for them, a mother and a wife. One of the members of the armed forces that was greeting their relatives there refused to speak to the press or any of us until he spoke to one of his superiors. He wanted some guidance as to what was the protocol of a member of the armed forces before he spoke to the press or any of us. I think that underscores the kind of allegiance he has to our nation. We were assisted by New York City, the Office of Immigrant Affairs of New York City, and eventually these cases were resolved. I entered the facility, Mr. Hoffman, and I say facility because he had all the characteristics of a jailhouse. And I was approached by members of your department and surrounded by them, accosted and surrounded by them. There was about 7 of them around me on my face as I advocated for these 3 individuals. What is your protocol within your department? I know that you were not briefed on the implementation of this new Muslim ban, and you may have been in disarray. But I was accosted and surrounded by members of your department Do you have a policy when addressing someone that's advocating for a person, not just a member of Congress, an attorney, a community organization? Is there a policy, Mr. Hoffman, to humanely deal with people that are advocating for folks that are being detained that are related to members of our armed forces? Do you have a policy for that?
Sir, we do have a policy for congressional engagement. Essentially, all members of Congress are to advise congressional affairs at headquarters and make arrangements or give the courtesy to make arrangements for visiting a port of entry.
Are we entitled to ask to speak to one of the superiors of those members of Customs and Border Patrol that are deployed to these airports?
Well, for Customs and Border Protection, if you do arrive at one of our facilities and we know that you're there, we should give you the courtesy to come out and speak with you.
Is there a way in which I can communicate with one of the superiors? Because I was denied that opportunity.
Well, sir, like I mentioned, typically there's a protocol in place whereby you'll contact Congressional Affairs here in Washington, D.C. at a national level, and they will make arrangements with the local port to advise you that they're coming and ensure we have the right representatives there and so forth.
Now, Mr. Hoffman, I'm 5'9". I was surrounded by folks that were from your department that I suspect were over 6 feet tall, about 7 of them over 200 pounds. I don't never carry a permit of a weapon, nor have I ever held a weapon in my hand. Do you perceive me to be a threat to them?
Sir, I can't speak to that specific instance. You know, I understand your frustration, and you know, I don't know what happened, so I can't speak to it.
Well, let me just state for the record, Madam Chair, that in my efforts to advocate for 3 folks, including a student at NYU High School, at NYU College, and 2 relatives of members of our armed forces, I enter what looked to be a holding facility in a jail. I was surrounded and accosted by members of Customs and Border Patrol, denying my right to contact one of their superiors. And I felt that that was a very threatening moment, not just for me, but for any American.
Gentleman,
I yield back, ma'am.
Gentleman yields back. The gentlelady from Texas, Ms. Garcia, is recognized for 5 minutes.
Thank you, Madam Chair, and good morning, and thanks to our witnesses for coming today, excuse me, to testify. The Muslim ban is yet, in my view, another tactic in this administration's use of anti-immigrant policies. This ban has impacted several of our districts, including my very own in Texas. And for the record, let me state that maybe the witness doesn't think it was chaos, but certainly the Inspector General thought it was pandemonium. The international airport in Houston was, in my view, complete chaos. There was news reports all of those days in the beginning of the ban from all around the country and the world showing the chaos. So it's so hard for me to believe that we have a witness today that is denying that. And in my district, some of this confusion, some of the fear, and some of the frustration still exists. I have a constituent who reached out to my office pleading for help in her K-1 visa. She states, and these are direct quotes, "I am the petitioner for my Iranian fiance, Baruch Sharifi. More than 2.5 years ago, my life changed when I met my now fiance. We decided to apply for the K-1 visa shortly after becoming engaged in Turkey. But much to our dismay, a month after we applied for the visa, the Muslim ban was expanded to include K-1 applicants, and since then, I've not been able to be with my fiance. The Abu Dhabi embassy, where he had his interview more than 14 months ago, does not seem to have a response as to when our visa petition will be approved. The petition is still in administrative processing with no change or update since July of 2018. I've tried reaching out to our U.S. senators, but have had no luck. I received a message from Senator Cornyn, that's our state Texas senator, applauding President Trump's cause and not offering any help for my case. Metaphorically, it was just another door shut straight on my face. These past 2 years have taken a toll on my dreams, yet my faith keeps me strong to continue fighting. I implore you, if there's anything you can do to help my case move toward appeal and approval, I would be grateful." That's signed by a constituent. Madam Chair, I would like her entire statement, which is a full page, to be entered for the record.
Without objection.
So it seems to me that there's still a lot of backlog and there's still a lot of distress on so many people still waiting. I ask each one of you, and just very quickly, because I'm only going to ask one question. Why is it just taking so long? As briefly as you can, because I've got to move on.
By far, the longest source of the delay was the intensive security clearance checks that had to be done in all waiver cases. And again, starting in July of this year, we have dramatically improved the speed of that process.
Well, and we look forward to those stats.
Yes, and
Ma'am, you're next.
I would just like to
I
say
need to move on,
that
sir.
one case that you mentioned, if you would let our team know, we'll look
We
into
have led everybody through the Congressional Liaison Office, et cetera, but nothing's happened yet. I just wanted to use an example. Ma'am?
Yes, ma'am. I share your concern that the security checks take so long. I would like to point out, and again, we can go to a closed session and maybe discuss this further, but for a lot of our vetting populations, not just these 7 countries, the process takes a long time. And we've been working for several years to try to automate things.
And, sir?
Ma'am, I'll defer to Department of State. The waiver process, for all
right,
practical
thank you.
purposes, rests with
Madam
them.
Chair, I yield the rest of my time to my colleague, Ms. Omar.
Gentlelady yields to the lady from Minnesota.
Thank you. I just wanted to follow up on a question. Who at the state or DHS is working on the 180-day review report? And how do we know that you're doing the review of the countries placed on the ban? If you can.
Yes, ma'am.
We're very short on time, so if you.
Yes, we do. The process that I was describing earlier, we conduct that every 180 days. We submit a report to the president at the end of that process.
And earlier you said that the state was not consulted in regards to the formulation of the Muslim ban. How did you know how to implement it, and what challenges existed because of it?
It was definitely very challenging, Congresswoman, and we did not have any advance notice or consultation about it.
Gentlelady's time has expired. The gentleman from Colorado is recognized for 5 minutes.
Thank you, Madam Chair. I first just want to echo the words of my colleagues and associate with their remarks. The policy that we're examining today certainly runs counter, in my view, to our American values, counter to our nation's founding, and counter to our morality and our humanity. From its inception, our nation has been a beacon of hope for the huddled masses who yearn to be free the world over. Since its founding, this land has been a safe haven for immigrants seeking a home, those fleeing persecution, those desiring the freedom to worship, and those placing their hope in the American dream and the belief that you can make it here if you try. We are all immigrants, and that certainly is true in my own instance as the son of African refugees. Yet since the moment President Trump was sworn into office, he and his administration have countered these ideals with anti-immigrant policies like the one we are addressing here today. The Muslim ban's most assured effect is to keep families apart. Indeed, this ban is one of the administration's first family separation policies in a litany of policies that followed. I would like to, as my colleague from Texas did, highlight a story of 2 constituents, Zachary Einerson and his wife, Shadi Semahi, whose visa application has been held in administrative processing since June of 2018. Shadi established and successfully ran her own business in Iran, which she closed in order to move and live with her husband. She is currently living in the United Kingdom as a dependent on Zachary's student visa while he completes a PhD program there. Luckily, the United Kingdom has allowed the 2 of them to remain together while they await the outcome of the U.S. immigration process. However, their temporary visa status in the UK is about to expire, which would force them to separate, Shadi back to Iran and Zachary back to the United States. This would cause them much undue hardship and, in fact, put both of their individual lives in physical danger. As a U.S. citizen, it's not safe for Zachary to live in Iran, and due to being married to a U.S. citizen, Shadi's in danger if she returns there as well. With the completion of Zachary's degree drawing near and his father suffering from a critical illness in Colorado, Zachary and Shadi are being forced to undergo life and death decisions about the well-being of their family and the safety of one another with no definitive resolution in sight. And so I just cannot phrase it more straightforwardly than Zachary did after submitting multiple documents demonstrating that Shadi has no criminal history, no assumption of threat or risk should be projected on Shadi simply because of her national origin or religion at birth. It is simply un-American to discriminate against immigrants solely because of where they come from or their religious beliefs. And I share that story because I think individual stories can get lost in some of the debate that we're having today about the technical intricacies of immigration law and the way in which this presidential proclamation has been implemented. And I hope that each of you will take these stories back to your colleagues because these are people who are struggling under what I believe to be, as I said, an anti-immigrant order. I will ask just a few questions, and I want to yield the balance of my time because I know we have a number of colleagues who'd like to get questions in as well. Following up on Representative Omar's point, as you all know, and I think it's been adduced in this hearing already, the proclamation requires DHS to produce a report every 180 days to the president. And it sounds as though in the prior exchange that has happened. Is that correct?
Yes, sir.
And has that happened every 100 days?
Yes, sir.
And are those reports public?
No, sir.
You can understand the difficulty we would have as members of Congress from an oversight perspective when there is a representation that this is being done for security reasons, and apparently those reasons, I suspect you are articulating that those would be within the substance of the reports that are being prepared for the president, and yet none of us have access to that document. And so to be able to apprise as to whether or not, in fact, the Department of Homeland Security is working to ascertain security procedures from this country so that countries can be lifted off of the order, it's a hard argument for us to take seriously. And we're not the only ones who have that skepticism. Justice Sotomayor expressed this, as I'm sure you're aware, in a recent federal case in which she noted that the results of the administration's review process had not been fully disclosed to the public, and that the few conclusions disclosed appeared not to have justified the ban. Pointing to documents filed in another federal lawsuit, she expressed doubt that a review of hundreds of countries' vetting practices, which, as you said, in your view, takes a long time, would result in an agency report of a mere 17 pages. So you can understand why this committee is very skeptical and why we will continue the vigorous oversight that we're engaged in today. And with that, I thank you, Madam Chair.
Gentleman's time has expired. The gentleman from New Jersey, Mr. Malinowski, is recognized for 5 minutes.
Thank you, Madam Chair. We've heard a lot about national security here, and I think it bears repeating that there has not been a single terrorist attack committed on U.S. soil by any national of any of the Muslim ban countries. What we have had are attacks by Saudis, by Pakistanis, by Lebanese, every single case my colleagues have mentioned, from a country that is not on the list. So the notion that we can trust these other governments to work with us to vet people coming to the United States is obviously preposterous. We've heard a lot about a list that the Obama administration produced a few years ago. Well, actually, Iraq was on that list, and Iraq is not now on the travel ban list for one reason, because influential Iraqis and the Pentagon frantically lobbied the White House at the last minute to take them off. It's not because they are able to work with us to vet travelers somehow better than these other countries. Now let's talk about a country that is on the list, Iran. We don't like the government of Iran. It is an odious dictatorship, but we constantly say that we love the people of Iran, that we are on their side, that we support their human rights. We know that Iran had nothing to do with 9/11. They are actually a sworn enemy of ISIS. And yet it is our national policy to say to the Iranian people, even as we claim to be on their side, that none of them are trustworthy enough to come to the United States unless they can go through this added hoop of proving that denial would cause them undue hardship. And I'm trying to understand this. What I hear from the State Department and from DHS is that we are looking for partners in these governments to help us figure out who can safely come to the United States, that we're working closely with a number of other countries to address our security and information sharing deficiencies, as you said, Mr. Ramatowski. Let me ask you both this question. Are we waiting for a partner in the Iranian government before we allow an Iranian grandmother to come visit her granddaughter in the United States? Is that what we're waiting for?
Congressman, no, we're not. That's why the waiver process and exception process exists in the proclamation.
Well, the
Because as you-
Iranians have one of the lowest rates of approval in the waiver process, even when consular officers say they should be allowed in. Let me give you a specific case. Leila Ali Karami, she's a human rights lawyer, an Iranian human rights lawyer, director of the Center for Supporters of Human Rights in Iran. She bravely defended Iranian dissidents before the revolutionary courts in that country and was forced into exile. She lives in the United Kingdom. She is subject to the travel ban. She cannot come to New York to lobby the United Nations to pass resolutions condemning Iran. Are we waiting for an Iranian partner, Iranian government partner, to allow her to come to the United States? It's been over a year.
I'll defer to DHS on the requirements, but if her case is pending a security review, we can look into it. I don't have any details on the particular case you raised.
Well, let me ask you this. What specific security checks are conducted on Iranians, Libyans, Syrians, people subject to the travel ban that we do not conduct on Pakistanis, on Saudis, on Lebanese, on citizens of countries that actually are responsible for 100% of the terrorist attacks that have been committed in this country? What checks are we conducting on these folks that we're not conducting on nationals of those countries? Can anybody answer that?
I can partly answer it, sir. First of all, under the additional executive orders that the President issued requiring enhanced vetting, visa applicants will be checked more closely at the embassy or consulate when they first apply. It might be a further anti-fraud review or some sort of extra analysis done at post. And then if the individual qualified for a waiver, the waiver would be sent in for the interagency review back here. That, up until July of 2019, was a very manual, labor-intensive, time-intensive process with partner agencies. We've automated that now, and that process is also being used for other visa applicants. It makes us significantly safer.
We're subjecting these people from countries that have committed no terrorist attacks in the United States to more onerous vetting and security checks. And on top of that, they have to prove undue hardship in order to get a waiver. And if you're from Saudi Arabia, you're from Pakistan, you're from Lebanon, none of that. Explain to me the national security justification for that distinction.
If I can, sir, the security checks that have been referred to are also done on nationals from other countries. It's the same process, and we would need to go into a classified setting to discuss how that process works.
It's the same process. Why have this?
The gentleman.
It's the difference between a waiver situation, which I will defer to my colleague from state to explain, and visa process checking.
The gentleman's time has expired. We will go to the gentlelady from Florida, Ms. Mukersel Powell.
Thank you, Chairwoman Lofgren, and thank you for all of you for coming here this morning. Now, I want to just take 1 second and put partisanship aside. You hear from the minority party many times that the Democrats don't care about the safety of our communities. And I want to make something very clear, like the chairwoman stated earlier. I wake up every morning making sure and thinking of ways of keeping this country safe, of keeping our community safe. It is why I have been advocating for gun reform since I got into Congress in January. But using a Muslim ban as a basis for national security, I think is just completely false. It's a sham. And many people have agreed on that issue. And I just want to talk a little bit about how this Muslim ban affects American citizens who may not look like any of the witnesses in the panel today, but who are American citizens and who are paying the consequences of this ineffective ban. I want to talk a little bit about the Sheriff family, who is Syrian, and they live in Miami. They live in my community. Raji came to the United States 7 years ago and lives in Miami. He's proudly worked his way through the immigration process, and he was so proud when he became a U.S. citizen in 2017, a privilege that I myself have, and several of my colleagues share that same privilege. We are U.S. citizens, we're also immigrants. In May of this year, Raji's parents applied for visas to come to this country with Raji, but the president's Muslim bans restrictions on Syria quickly stalled the process. Raji's parents were stuck in limbo waiting with no answers. They're hardworking people, they are not criminals, they are not terrorists, but they were very confused. After months of waiting, Raji's mother finally was able to make it to the United States using her Lebanese passport. But Raji's father did not have the same luck, and Raji's father remains in Syria today, while his family is in the United States waiting. Because of this ban, a good family has been ripped apart. Raji does not know when he's going to be able to see his father again, and the possibility of reuniting the family grows slimmer every single day. And as we know, the story of the Sharafs is not unique. The ban has impacted hundreds of thousands of people based on unfair criteria. And I think that what is clear is that the ban is not simply about stopping people from the Muslim faith. It's a proclamation that is based on fear. It is not right, and it goes against our American values. Now, with each iteration of the Muslim ban, a bipartisan coalition of dozens of former national security officials who have worked in both Democratic and Republican administrations have rejected the basis that this ban was used based on national security threats. The Trump administration's own Department of Homeland Security, DHS, the Office of Intelligence and Analysis, disputed the national security benefits of the ban, which have remained the primary justification for this ban. And a report of the office indicated that citizenship is an unreliable indicator of a terrorist threat to the United States, and that nationals of the countries targeted in the first iteration of the ban are rarely implicated in US-based terrorism. So I want to ask you, my first question, do you disagree with this report, and if so, on what grounds? Ms. Newman.
The Office of Intelligence and Analysis, and can you remind me the date of that?
I think it was back in 2017. I don't have the exact date in front of me.
I have a vague recollection of it, and I apologize. I did not review that in preparation for the hearing. They are independent as an intelligence community member, provide their assessment. I think my testimony and my focus has been on the work that's occurred since Proclamation 9645, which I believe that was written separately.
I'm just asking if you agree or not with that report.
I think it's focusing on the false premise, right? It's not about the citizenship being a determinant of whether somebody's a terrorist. What we're looking at is whether the identity credentialing or the information sharing that individual is associated with is sufficient in order for us to know that they are who they say they are and that they don't pose a risk to the United States. And so without absent seeing the full report, it's hard for me to comment specifically, but from what you read, it seems like it's drawing a different distinction.
It's very clear. It's basically that it's not a reliable indicator, depending on the nationality of where your passport is coming from.
Gentlelady's time has expired.
Gentlelady's
time has expired. The gentlelady from Texas is recognized.
Thank you, Madam Chairwoman, for calling this very important hearing. Thanks to all of you for being here. I really appreciate it. It's hard to believe that we're just now getting to the Muslim ban. And when you think back, when all of us think back on the last 2.5, almost 3 years, all of the anti-immigrant policies that have been rolled out under this administration, it's hard to keep track, in fact, of how the erosion of our values, just how rapidly it has happened. These hearings are really important because they help shed light on the human toll that policies take, and there is a real human toll. I would like to just very briefly ask for unanimous consent to allow testimony.
Without objection, then.
Thank you. A story from one of my constituents. We've been listening to the human toll and the human impact. I have a constituent whose fiance is in Iran and who has been waiting for this waiver, waiting for her visa. And during that year and a half that they've been apart, they have suffered financial hardship, emotional hardship. They have grown despondent, very depressed, lots of anxiety. The impact to them has been really devastating. And so I have a couple of questions about that, but I do want to also say that we don't have to sacrifice our values in order to obtain and attain and retain security. It is possible, absolutely possible, to be a secure nation and to celebrate and uphold our values all at once. So my first question is, my constituent has been waiting for almost a year and a half. Why is the process taking so long? Can someone give me a succinct answer?
Yes, Congresswoman, it took time to set up a waiver process at the beginning, and the security checks required, the intense manual interagency security checks required in order to issue the waiver were the largest source of delay. Let me just say that, we are very cognizant of the impact on human beings by this delay, and we are working as hard as we can to minimize it.
I understand that there's this idea that in response to inquiries and lawsuits that the State Department says that each applicant has to wait in line, and obviously we know that's a very long line considering the wait time that some of our constituents have had to live through. How do you keep track of the order of people in line?
Let me just say, Congresswoman, that we do expedite cases of really urgent humanitarian concern, emergency medical, things of that sort. We regularly contact embassies and consulates and ask them if you are aware of a particularly urgent case, particularly in the first year of the process when the security vetting was much slower. We wanted them to signal to us that this was an emergency case, and we would do our best to process that.
For the non-emergencies, though, is it a question of resources? Is it, what is, I'm trying to, it's a question of resources.
It's a question of resources and capabilities at partner agencies that have to do the manual deep dive research. But as I mentioned, beginning in July, a large part of that is now automated. And so just in the past 2 months, we've doubled the number of waivers issued. There will be more and more going forward from this time. I'm sure some are being issued today. So we expect that there will be a significant decrease in processing time for everybody.
And I have a question about those folks who were not offered a waiver during the first 2 iterations, and now under the 3rd iteration, are they being reconsidered for a waiver?
We will reconsider any case at any time, Congresswoman, even if the initial decision is a denial. If an applicant chooses to reapply again because their circumstances are different, we will reconsider that case anytime.
Are we able to have copies of the various rules that have changed via each iteration? Could Congress get a copy of that, these 2 committees?
You mean the presidential proclamations and all?
The processes and policies that you all are using to evaluate.
Yes, we did provide a variety of guidance, information, and other directives to the committee in response to a written request from the chair. We've already done that. We can brief on the security clearance process in closed session if you would like. If there's a particular case or more of concern to you, our team is happy to look into that and let you know what is going on with it.
Unfortunately, my time has expired. Thank you so much.
Gentlelady yields back. The gentlewoman from Texas, Ms. Jackson Lee, is recognized for 5 minutes.
I thank the chair for this hearing, and I thank the witnesses as well. Many of us have had the State Department and Department of Homeland Security before us on many occasions. As I would, let me thank all of you as public servants for the work that you do, even though the policies of which you're here for have, I believe, have no grounding in reality and opposing a difficult posture. Let me just quickly indicate the first order, January 27, 2017, Iran, Iraq, Libya, Somalia, Sudan, Syria. Then we move on to March 6, 2017, Iran, Libya, Somalia, Sudan, Syria, Yemen. Move on to September 24th, Chad, Iran, Libya, North Korea, Somalia, Syria, Venezuela. Let me try to ask the State Department, were you involved in the iterations rather, of these executive orders?
Not for the first version, Congresswoman, but subsequently there was an interagency process that reviewed the executive orders and the proclamation.
So in the rush to do the first one, you were not engaged?
We had no advance consultation.
And as noted by the Inspector General of DHS, there was widespread confusion at the nation's airport, pandemonium within the administration, noting that the agencies charged with implementing the ban were largely caught by surprise. To Customs and Border Protection, did you know anything as the first ban was issued?
No, ma'am. I became aware after signature.
So there were your officers at the nation's airports, that were international airports, that were confronted with travelers who had already left their place of departure, coming into the United States, who left their place of departure and had no knowledge of a change in policy.
Correct. We had people in real-time travel.
You had people who had heretofore legitimate documents, such as a tourist visa, who were coming into the United States that would be detrimentally impacted by the Muslim ban.
Potentially, yes.
With that in mind, I know how orderly CBP is. You want to follow the law. Did that put your officers in jeopardy as they dealt with individuals who likewise would have felt they were in jeopardy and might have been impacted in such a way that inappropriate behavior on both parts might have occurred, both groups not knowing what was going on? Fear, for example.
No, I don't think it didn't put the officers in jeopardy. As I mentioned earlier, since it was effective immediately and we were notified after signature, it was a challenging implementation to get the policy.
Do you think it might have put the visitors in fear who had legitimate documents?
I wouldn't say put them in fear, no.
Well, let me beg to differ with you. I beg to differ with you for Mohammed Abdul Qadra, a 16-year-old Jordanian who had lived in the United States with his brother who had a green card. He was a Katy High School student. I was called to the airport, Bush Intercontinental Airport, who I have great respect for those individuals that work there for your agency. This individual had gotten off the airplane, innocent child that he was. He had gone home to renew his documents, which he did renew, which were a tourist visa, and he was coming, an unaccompanied child. It was an innocent child who had gone home to renew his documents because they had expired. Of course, they hadn't expired when he got home, so he appropriately got him back from Jordan, an ally of the United States, but he was a Muslim. The teenager looked every bit a part of the diverse American youth that we trained. He was here getting improving his English, but when he was questioned, it looked as if he was going to school here, and he was detained. His family could not access him. No one could access him. He had a slim-fitting shirt, button-up collar, rolled-up jeans, big blue watch, just like any of our teenagers. And he was immediately, after maybe staying in a detention cell, that he was probably fearful for his life because he is coming here unknown to what is going on, was sent to a children's center in Chicago. It was my office, along with his lawyers, that worked diligently to turn that into a short-stay basis, the ones that we see, the children in the H8 centers today that are in there for a year, 6 months, 4 months. Do you believe that he was afraid?
Maybe under the circumstances, probably he could have very well been afraid. But again, we treat everyone with dignity and respect. We let them know what's going on throughout the process. And I trust our officers treat that individual with dignity and respect, understanding the sensitivity of the case.
The ban caused his fear. Thank you. I yield back.
The gentlelady from Pennsylvania, Ms. Scanlon, is recognized for 5 minutes.
Just wanted to speak for a minute to the immediate impact of the Muslim ban. At that time, I was not in Congress. I was pro bono counsel at a national law firm, and I ended up spending that long weekend, I know it was a long weekend for you, organizing lawyers to go out to various airports. So I had lawyers at JFK, I had lawyers in Atlanta, in LA, and in Philadelphia. And just as an example of the chaos, I'd ask unanimous consent to introduce into the record this article from the Philadelphia Inquirer from January 30th, 2017, how Philly reacted to Trump's...
Without objection.
Okay. It described how the first people to land in Philly who were subject to the Muslim ban were two Syrian Christian families who had visas and green cards, and they were sent back because Customs and Border Patrol didn't know how to deal with it. They weren't allowed access to their attorneys. And of course, we had a large number of protesters outside. Several of the other members have spoken to their experiences on that day. I know John Lewis went to the airport in Georgia and was also denied access to folks who were entering. And as is his custom, he had a sit-in. But so just moving to Mr. Rakowski, yes. You have told us several times that 7,600 visa waivers have been granted as of this month, correct?
September 14th, yes.
Okay, and that's since the inception of
That's correct.
this ban. Okay, so over 60,000 people subject to this ban have applied during that time, right?
Approximately that number, yes.
Okay, can you give me a more specific number? I know the 60,000 number was as of March.
The number that I have here in terms of totals is about 72,000.
Okay, so 72,000 people have applied, and you've managed to put out 7,600 waivers.
Right.
Roughly half of them in the last 6 months.
Roughly half of them in the last 2 months.
In the last 2 months, okay. And so again, looking at those total numbers, if we've got, how many, 72,000?
That was the grand total of applications, yes.
Okay, so 72,000 applications minus 7,600 waivers granted, and then you also said that there have been 31,334 refusals?
Approximately, yes. And
Okay.
approximately 15,000 cases are still ongoing through the security process.
Okay, so we've got over 33,000 people who haven't had an answer yet, right?
About 15,000 of them.
Okay, so 15,000 haven't gotten any answer. What happened to the other 18,000?
They were denied. They didn't qualify for a waiver.
Okay.
Or they were denied. You know, the figures I have, Congresswoman, I can
Yes.
quote for you. Out of the grand total, 12,912 were denied for other aspects of immigration law.
Okay.
7,679 waivers, 5,137 visas issued as exceptions. And then of the 46,334 remaining, we estimate that approximately 15,000 of that total is awaiting the security review.
And the 46,000.
The remainder of that would have been denied because they
Okay.
did not fit one of the waiver criteria permitted under the proclamation.
Okay, that's helpful because the
Right, it
numbers
helps
were
you
not
view
adding
the-
up and the percentages were not adding up. You've said a couple times if people are having trouble with this. I have a staff member who has an 86-year-old grandmother from Iran who used to regularly visit the country to visit her family. She applied over a year ago. We have done congressional casework on this, no response. So who should members of Congress or who should the folks waiting for a decision on these outstanding applications, who should they be contacting?
You should still contact the Department of State for an update.
We've done that
Because
repeatedly.
Yes, because the waiver security screening process has significantly improved, and so we are seeing a lot more movement in cases that have been delayed for a long time.
Who is operating the waiver security process? Who's the final say on that?
The Department of State is the implementing agent.
Whose desk is it on? Is it
It's
yours?
not on any of our desks. It goes to partner agencies in the law enforcement and intelligence
So
community.
it's just like this giant computer that you put it in? Who has the final say for these people?
We survey a lot of databases.
Who's we?
The Department of State. We're the executive agent of this process.
Particular
We bring
agency?
the case back. I'd have to brief in closed session on the specific agencies and what they exactly do, but they are part of the law enforcement. And
The gentlelady's time has expired, but the gentleman could answer by saying it is the Department of State that finally issues.
That's right. Because
Thank you.
It comes back to us and we send it.
I have asked unanimous consent that the following statements be included in the record: a statement by 19 state attorneys general, statements from the American Civil Liberties Union, the American Arab Anti-Discrimination Committee, the Anti-Defamation League, Amnesty International, the Asian American Advancing Justice, Bend the Arc, Church World Services, Council on American Islamic Relations, the Engage Foundation, Friends Committee on National Legislation, Japanese American Citizens League, Muslim Public Affairs Council, National Council of Jewish Women, National Immigration Law Center, Jews and Muslims and Allies Acting Together, Public Affairs Alliance of Iranian Americans, International Refugee Assistance Project, and a statement from Senator Coons and Representative Chu on their legislation called the No Ban Act. And without objection, those statements will be made part of the record. Mr. Abera?
Madam Chairwoman, I also would ask, we have a letter dated September 23rd, 2019, from a variety of national security experts, Democrats and Republicans, who have had the highest security clearance, commenting on the nature of the ban and how it doesn't make a statement.
Without objection, that is included. We will be in recess for 5 minutes waiting for other panel, but before you leave, I'll just note that the record will be open for 5 days, during which members may ask additional questions of the witnesses. We would ask that you respond promptly. One of those questions will be how we got from 15,000 Syrian refugees in 2016 to 11 this year, only 11, and whether that was part of this process or some other process. With that, we will be in recess for 5 minutes, and then we will have our second panel. The subcommittees will resume from our recess, and I want to thank the witnesses for coming today. I want to introduce the second panel and apologize. Let's see, I'm losing my track of my place in the I'm looking for the biographies of the panel, and here we have Dr. Abdallah Iman I'm mispronouncing your word. Dezangi is an assistant professor of computer science and director of the Master of Science in Bioinformatics program at Morgan State University. He was born in Iran and is now a legal permanent resident living in Baltimore, Maryland. He holds a PhD in computer science from Griffith University in Brisbane, Queensland, Australia. And because of the ban, his wife, Gazela Taharizada, who he married in Australia in 2015, and who has filed for an immigrant visa to come to the United States, has been unable to come to the U.S. and to live with him, her husband. He also has a PhD. She also has a PhD and received a postdoc job offer at the University of Maryland, College Park, with work funded by the National Institute of Health. However, because of the ban, she has yet to obtain a visa to come and join her husband, as well as to do this distinguished work in the United States. Mr. Ismail Al-Ghazali is a U.S. citizen who was born in Yemen and currently lives in Brooklyn, New York. He and his family have also been impacted by the ban. To date, he remains separated from his wife, sister, 5-month-old daughter, and 1.5-year-old son. His wife has attempted to obtain a visa to return home with Ismail until recently. The ban prevented her from doing so. She was in processing for almost 3 years before being approved for a waiver earlier this month. We thank Mr. Al-Ghazali for taking the time to share his story with us today. Farhana Kara is the co-founder, president, and executive director of Muslim Advocates, a national legal advocacy and educational organization. Previously, she served as counsel on the Senate Judiciary Committee and worked under the Constitution Subcommittee Chairman, Senator Russell Feingold. Prior to working for the United States Senate, she worked as a litigation associate with several law firms. In her current role with Muslim Advocates, she testified before the Senate Judiciary Committee's Subcommittee on Oversight, Agency Actions, Federal Rights, and Federal Courts on the topic of anti-Muslim rhetoric and its connections to law enforcement. She received her bachelor's degree from Wellesley College and her Juris Doctorate from Cornell Law School. And finally, we have Arthur Andrew. The Honorable Arthur is a resident fellow in law and policy for the Center of Immigration Studies and the former immigration judge at the York Immigration Court in Pennsylvania. Mr. Arthur has also served at the former Immigration and Naturalization Service General Counsel's Office and worked on Capitol Hill as counsel to the House Judiciary Committee and House Oversight Committee. He received a bachelor's degree from the University of Virginia and a Juris Doctorate from George Washington University School of Law. We welcome all of our distinguished witnesses and thank them for participating in today's hearing. We are particularly honored to hear from the two witnesses personally impacted by these policies and commend them for their courage and strength in sharing their personal painful stories with us today. Now, if you will please rise, I will begin by swearing each of you in. If you'll raise your right hand, do you swear or affirm under penalty of perjury that the testimony you are about to give is true and correct to the best of your knowledge, information, and belief, so help you God? and the record will reflect that each of the witnesses answered the affirmative. Thank you. Please be seated. As with the prior panel, each of your written statements will be made part of the record, and so we do ask that your testimony consume about 5 minutes. We have a light system, so when the yellow light goes on, it means you've got just a minute left, and when the red turns on, it means that your 5 minutes have expired, and we do ask that you try and wrap it up at this point. So, Dr. Dehan Ghazi, you will begin.
Dear respected members of the U.S. House of Representatives, thank you for your service and for giving me the opportunity to share my case and story regarding the Muslim ban and how it affects me and my wife, Dr. Ghazaleh Taherzadeh. I'm one of the thousands that have been affected by the Muslim ban and represent the most heavily impacted community, which is Iranians. One of the saddest stories of separation and heartbreak. People who came to the United States to start a new life in this wonderful country, and like many others, have strived to help make their new home a better place. Yet we have been banned for no reason other than where we were born and what religion we practice. It is our story that I would like to share with you. I'm Dr. Abdullah Rezangi, Assistant Professor at the Department of Computer Science, Morgan State University, Baltimore, Maryland. I'm also Program Director of MS in Bioinformatics at this institute. I met my wife, Dr. Ghazaleh Taherzadeh, in Malaysia back in 2008, while we both were students at Multimedia University. After I moved to the United States, we decided to enshrine our love in marriage. We realized that after 8 years, we no longer can be apart and long to spend the rest of our life together. We were happily married in September 2016, and I filed an I-130 petition for her to join me by October 2016. We knew this process was going to take up to 2 years, so she could join me after she completed her PhD in Australia at Griffith University. However, our dream and hopes were all shattered after the announcement of the Muslim ban and on nationals in several countries, including Iran. This cruel policy threw our lives in disarray. By April 2018, Ghazaleh received an offer to serve as a postdoctoral research scholar at the University of Maryland. Her aim is to conduct high-impact research in the field of bioinformatics, drug design, and drug discovery. So it would have been a wonderful opportunity for her. However, despite the efforts from the UMD, she was not able to apply for H-1B visa out of the United States because of travel ban. She finally was invited for her interview in February 2019, during which her visa application was denied. We were greatly dismayed, despite knowing this was a possibility as a result of Muslim ban. So we completed a waiver request with a supporting letter from Senator Van Hollen of Maryland. Again, with the help of Senator Van Hollen, we followed up after 6 months in August, as had been advised, but was told the process would take even longer than that. Unfortunately, there is no timeline. She has lost the job offer that was extended to her, as there was no end in sight to this ban. Denial of her visa and entry caused us and our family undue hardship because we missed the support and companionship that we desperately seek. My wife is alone in Australia, and I'm without her here. I'm separated from the person closest to me in life, and I don't know when we will get together again, forced to go through the celebrations and hardship in our life apart. Denial of her request for a waiver or further delay in this process will force me to quit my service at Morgan State University to reunite with my wife in Australia. Such an act will be a loss to my university, Baltimore City, state of Maryland, and the United States in general. I would also have to leave behind my mom and 2 brothers who live in the United States. It is a very hard and heartbreaking decision to make. Our hope was to move to the United States, pursue our careers and dreams, build a family, and contribute to the well-being of our society and community. I also feel uncomfortable that as a program director and supervisor, I have to leave my student behind. But there is no alternative for me. I have to be with my beloved wife, and I'm being denied my love and future because I'm Iranian. As I finish this testimony, I finish to leave you with the knowledge that this unfair and xenophobic ban is destroying our life and bond. We do not know what's going to happen and how long we have to wait. For all the reasons above, we would like to raise our voice to the House of Representatives, a stronghold of law and order based on the U.S. Constitution, to please help us to build our lives and stop this injustice. We're one in several thousand that have been affected by the Muslim ban. Many more have a similar story, similar hardship, and similar sorrow and sadness. Those that hope to one day call this land of free and home of the brave their home, and serve this country under the same flag as those can be for them. Yet they have been banned because of their nationality and religion. This is discrimination. Thank you very much for your time.
Thank you very much. We now will turn to Ismail Al-Ghazali.
Thanks. Good afternoon, Congressmember. Thanks for giving me the opportunity to share this with you. My name is Ismail Al-Ghazali. I live in New York City, one of the greatest cities in the world. I work at a bodega, a small neighborhood market in Brooklyn. This work doesn't make me rich, but I love it because I get to meet so many people of all race and all religions. I know all my regular customers by name. When they come to my store, I want to take care of them. Today I'm here to tell you the story of my family. My wonderful wife, Hind, and our two childs, Khalid, my son, who's a year and a half old, and my newborn daughter, she's 5 months old. In fact, I never even met my daughter yet. I never hold her in my arms. I've only seen her through photos and videos. I do not have words to describe the love that I carry in my heart for my wife and my kids. It hurts me so much that it's been now more than a year since I've seen my family. Hind, Khalid, and Rahaf and I were separated by thousands of miles because of the Muslim ban. I know I wanted to marry my wife, Hind, right away after I met her. We fell in love and got married in 2013 before our family and friends. Hind has the best heart. She wanted to take care of people. In fact, her dream to become a nurse. She can't do this in Yemen, but she can pursue her dream in America. We had just been married, but I had to leave Hind behind and go back to America. I had to feed my family. My job was back in Brooklyn. I needed to be in the United States to apply for my family to join me. In my heart, I felt that we will be together in America soon. I am a U.S. citizen, and she's my wife. We were married. What could go wrong? After the first visa interview in New York, I returned to Yemen to be with Hind. After 2 long years of waiting, the date for our immigration interview had finally arrived. My friends and coworkers loaned me the money that I needed for this trip. Together, we traveled to Djibouti for the interview. When we arrived, my wife was 8 months pregnant with our son, Khalid. Her pregnancy had been difficult. Doctors had discovered she had a heart condition. We know that the Muslim ban stopped Yemenis from entering the U.S., but we also know it allows family members of U.S. citizens. Hind should have been eligible for a waiver. I'm a U.S. citizen, and she's my wife. And she needed medical care for a serious health condition. But the interview did not go as we expected. It didn't even last 5 minutes. They returned Hind's passport and said that her visa is being denied because of the Muslim ban. Even though Hind was my wife, we were not eligible for a waiver. We were stuck in Djibouti. I was not able to work there. The money that I borrowed was running out. I wasn't sure what to do next. Hind went into labor late one night. For most couples, this is a happy occasion. For us, it was the most scariest experience in my life. It took me 30 minutes to find a cab while my wife was in pain. Hind contractions were coming faster and faster, and we were 5 minutes away from the hospital, but there was no time left. My wife gave birth to our son Khaled in the back of a cab. I will never forget this night and how hopeless I felt. I stayed as long as I could. I had 10 months to be with my family, but I had to go back to New York and provide for them. And Hind was expecting our second child. Leaving them again behind, it was more painful than I could imagine. And in April of this year, my wife gave birth to our daughter Rahaf back in Yemen, and it broke my heart that I wasn't there for her. Now I have been asked to come back and re-interview for the waiver. I still have hope that we will be together again as a family here. Hind will become a nurse. My son and daughter will go to school and pursue their own dreams. I pray that you will find it in your heart to allow families like mine to be together. Please end this ban. Thanks for listening.
Thank you very much. Farhana Kara, we'll hear from you now.
Good afternoon. My name is Farhana Kara. I'm the Executive Director of Muslim Advocates, a national civil rights organization. Since early 2017, we've been fighting the Muslim ban in the courts and working with Congress to right this wrong. Chairs Lofgren, Bera, members of the committee, thank you for holding this historic hearing, the first congressional hearing on the Muslim ban. Your presence here signals your commitment to protecting civil rights for all. Ismail and Abdullah, thank you so much for your courage. You speak for thousands of Americans who are hurting today because of the ban. So how did we get here, and what can Congress do? In January 2017, just 7 days after his inauguration, President Trump issued an executive order banning people from 7 predominantly Muslim countries from entering the U.S. Thousands of Americans flocked to airports across the country in protest. As court after court ruled that the Muslim ban was unlawful, the president issued 2 revised versions of the ban, versions that claimed to include exceptions in a waiver process. Immediately after the 3rd ban went into effect, thousands of blanket denials for visas were issued before individuals even had a chance to apply for a waiver or demonstrate that they were eligible for one. According to recent data from the State Department, of roughly 60,000 visa applications received during a 16-month period, only 5.1% of the waiver requests were granted. And to date, there is no waiver process available to the public. As we feared, the so-called waiver process has been a sham. We believe that the vast majority of the waivers sought involve Americans like Abdullah and Ismail seeking to be reunited with their family, or individuals seeking urgent medical treatment. There are people like Maral Tabrizi, a green card holder, married to a U.S. citizen who recently gave birth and desperately wants her parents to visit from Iran so they can hold their grandchild. Or Afkab Hussein, a Somali refugee and green card holder who arrived in 2015 with the promise that his wife and newborn son would soon join him. Even though they were approved for resettlement nearly 3 years ago, they have not yet been allowed to join him here in America. Or people like Hossein Barati, desperately waiting for a visitor's visa so he can undergo specialized treatment for stage 3 cancer, treatment he cannot otherwise receive in Iran. The Muslim ban demonizes and dehumanizes Muslims, evoking dark chapters of our nation's history. The story of immigrant Jews, Irish, Italians, the stain of Japanese American internment camps. Each of these groups was shunned and isolated for their otherness. But America prevailed when these groups stopped being seen as outsiders and started being seen as neighbors. And that's who American Muslims are, your neighbors. We are your dentists and patients, your teachers and students. We are baristas and barbers, politicians, and even stand-up comedians. But most importantly, we are husbands and wives, parents and children, brothers and sisters. This is why the Muslim ban hurts us on a deeply, deeply personal level, because we know it is contrary to the welcoming country we aspire to be. But here's the good news. The President and the Supreme Court do not have the final say. Congress does. Earlier this year, Congresswoman Judy Chu and Senator Chris Coons introduced the No Ban Act, a bill that would terminate the current Muslim ban and would amend the law to ensure that no president can enact a similar discriminatory ban again in the future. But most importantly, it would bring immediate relief to thousands of Americans who are separated from their loved ones today. We urge Congress to pass the No Ban Act and remove religious bigotry from our nation's immigration system for good. And in the meantime, we urge the administration to make good on its promise to issue family-based and humanitarian waivers immediately and without further delay. Thank you for this opportunity to testify. I look forward to your questions.
Thank you very much. And our final but not least witness, Mr. Arthur, you are recognized for 5 minutes.
Thank you, Madam Chairman. Chairman Lofgren, Chairman Barra, ranking members, and members of the joint subcommittees, I thank you for inviting me here today to discuss this important but often misunderstood issue. Protecting the safety, institutions, and well-being of the American people, citizens, nationals, and lawful immigrants is the primary duty of the United States government. For decades, individuals, both foreign and domestic, have posed risks to our people and our institutions the U.S. government must constantly combat. Domestically, it is the role of our federal law enforcement agencies and their state and local partners to investigate and prevent such harm. With respect to threats from abroad, the State Department, DHS, and our intelligence agencies must be constantly vigilant to ensure that individuals who pose a security or public safety risk are unable to reach our shores. State Department consular officials and CBP officers play critical roles in that effort. Millions of foreign nationals seek visas to enter our country each year, and it's their job to screen each of them. State and CBP must ensure that those individuals are who they claim to be, are coming for the reasons they assert, and will remain only as long as permitted. Presidential Proclamation 9645 and the review that led to that issuance assist them in that effort. In that review, DHS, with the assistance of state and the DNI, developed a baseline for the information needed to identify visa applicants and assess whether they pose security or public safety risks. This begins with travel documents. The documents presented are not reliable or can't be verified. They're worthless for identification purposes. Next, our officers rely on information provided by foreign governments to assess the risk posed by visa applicants. Vetting is only as good as the information U.S. officials have at their disposal. Finally, an assessment of country conditions, and in particular whether terrorist groups operate in those countries and whether those countries themselves are hostile to the United States, are critical facts in assessing the intentions of any individual visa applicant. Terrorists have and will attempt to exploit our generous immigration laws to attack this country and to use this country as a base for operational planning and fundraising. The same is true of criminals. Those efforts undermine our domestic security and our foreign policy goals. By restricting the entry of specified classes of individuals from a limited number of countries, PP 9645 makes it easier for our officers to subvert those efforts and avoid those risks. Respectfully, I question this hearing's characterization of PP 9645. It is not a ban because although it restricts the entry of foreign nationals in certain visa categories, those restrictions are subject to exceptions, limitations, and waivers, as we've heard. Our government agencies are constantly improving their practices to ensure that those waivers, in particular, are adjudicated in a timely fashion consistent with security concerns. Nor is it a Muslim ban because, as the Supreme Court has noted, and as has been stated many times here, it makes no reference to religion, covers just 8% of the world's population, and is limited to countries that were previously designated by Congress or prior administrations as posing national security risks. Any Muslim ban would be contrary to the religious freedoms upon which this country was founded and from which the strength of this nation arises. Believers of all faiths and adherents to no faith at all contribute to our institutional and economic strength. From a national security standpoint, such a ban would be counterproductive. It would gain for us the enmity of 1.8 billion people and would substitute an irrational bias in our visa screening system for a logical policy focused on responding to real-world threats. As the Supreme Court held, PP 9645, quote, is expressly premised on legitimate purposes, preventing entry of nationals who cannot be adequately vetted and inducing other nations to improve their practices. As an individual who has advised attorneys general of both parties and Congress on national security issues relating to immigration, I concur in that judgment. Thank you, and I welcome your questions.
Thank you. The gentleman yields back. Now is the time when members of the committees will have an opportunity to question witnesses for 5 minutes each. I will turn now to the chairman of the Oversight Committee and Foreign Affairs, Mr. Bera, for his 5 minutes.
Thank you, Madam Chairwoman. And thank you to the witnesses for being here, and particularly Dr. Dezangi and Mr. Al-Ghazali for sharing your stories. The purpose of this hearing really is to put a human face on this. And before I launch into my questions, I think it's not a binary choice. We can both hold on to our values as a nation of immigrants, of a welcoming country, but also guarantee, to the best of our ability to protect our national security. Those are not givens. And when I listen to the two stories here, but also when I think about the cases of my own constituents, you've provided quite a bit of documentation that could be vetted, that could be looked at, that would suggest that neither one of your spouses or kids are security risks. So there's plenty of document to say, well, we don't have this information to do the vetting process, just smacks of insincerity right now. In my own district, we currently have 39 open cases that, as far as we can tell, have not moved anywhere in the last 6 months. And it's only when we've intervened through the media and others that we've been able to get the process unstuck. So my hope is, based on this new automated system, that backlog will get cleared up, that we will be able to move folks through here. And again, I hear far too often of folks that are being kept from their families. The best estimates that I can get from the Brennan Center is that the Muslim ban's kept over 3,800 partners from their American spouses, over 1,500 children from their American parents, and over 3,400 parents from their American sons and daughters. Now, we can do better than that, and we must do better than that. And the No Ban Act will help us do better than that. Ishmael, let me ask you some questions, if I might. We understand from the State Department that they don't consider being in a conflict zone an undue hardship. And your wife is in Yemen, which has been subject to years of wars and conflicts. Would you consider the conditions in Yemen to be undue hardship?
Yes, the Yemen is really in the hardship right now. You're talking about in a country where people live in darkness. As a matter of fact, after I was separated with my family, when they returned to Yemen, I called my wife like 2 weeks later after they arrived in Yemen, and there was no baby food or no milk at any supermarket. It's a country under war, That's what have me.
That sounds like the definition of undue hardship. Ms. Karen, your advocacy work, there doesn't seem to be a real valid definition for undue hardship, and national interest requirements receive the waiver. From your experience, what is that definition? How is that definition being applied?
Thank you, Congressman, for that question. And let me first say that we have, Muslim advocates have had some insight into what the State Department has been doing and how it's been treating applicants who are potentially eligible for waivers, in part through our litigation that was brought with our colleagues at Lutfi Legal. It's a class action lawsuit brought on applicants who are seeking waivers in federal court. And as a result of that litigation, the court has ordered the government to produce information to try to get an understanding of what guidance has been given internally to consular officers. Also, as a result of that litigation, we've been speaking with consular officers, including some of the folks that Congresswoman Umar referenced earlier, and they paint a very different picture from what we've heard earlier today. And specifically, there isn't clarity, especially to the public, about what these standards mean. You refer to undue hardship. There's a reference to a national security check also, that the admission of the applicant is in the national interest of the United States. And internally within the department, there's been numerous guidance, sometimes conflicting at times, and not a whole lot that's been shared publicly. So we have basically the public operating in the blind, people just trying to do their best to make the case for why their spouses, their children, their grandmothers should be allowed to enter the U.S. And so we have a really broken system. And the State Department officials' representation earlier today that, well, things are now, now they're starting to move. Since July, the last couple of months, things are really starting to move. From our perspective and what we've seen and from what we hear from families, from immigration practitioners, that is just a drop in the bucket in terms of the number of applicants that are waiting. And they've been waiting for years now to really see progress and to get these applications approved. These are U.S. citizens, green card holders, who in the normal course can have their family members come and attend births, weddings, and join their family members here in the United States.
The gentleman's time has expired. We now will turn to the ranking member, Mr. Biggs.
Great.
Thank you, Madam Chair. And I appreciate all the witnesses coming and telling your story and what's gone on in your life. I will say that I think it is unfortunate to continue to refer to this as a Muslim ban. I thought we might have put that to bed in the last hearing. And I'm interested in how at least one of you testified that the ban, which is not really a ban, it's a limitation and it's a review, said that this applies to 7 predominantly Muslim nations, and then quoted old data. Data that we heard earlier specifically stating that refuted that old data, which I thought was interesting. And yet, the same witness just poo-pooed the entire hearing that we just had. I think that's unfortunate. And then that same witness said there's no waiver process available to the public. And yet, that seems to be an astounding misunderstanding of the process to obtain a waiver. We had an expert come in and talk about everyone who's applying for a visa in this category has a review to determine whether they qualify for a waiver. There's not a second affirmative requirement because, as the State Department official said, look, if we figure if you're going to apply for the visa, you must want the waiver. So we're not going to put them through the second process. Now, does it take some time? Absolutely, because the testimony was pretty clear. And my experience in following this on other immigration issues is you're trying to develop communication with certain nations so that you have veracity in the documents that you're reviewing, you're having veracity in the testimony that you're hearing, so you know who the individual is and you know what they're saying to be true or accurate. So I'll give you a rather homely example, but we have the 3 Northern Triangle states. We could not send people back who had received due process in the United States because there was no travel papers. They required travel papers. So you couldn't send somebody back. So we ended up detaining them much longer than we should have and wanted to. Now all 3 of those nations have complied and had a more open, more transparent process, and now they don't require those travel papers. So they can be removed after they've had their due process if they're removable. The same thing goes on here in it's not necessary that an individual they may be a wonderful person, but the requirement that we place on our customs officials and our Homeland Security officials is to determine whether they're who they say they are and if they're a threat to the country. And that may require, in fact, in all cases, requires some kind of communication with the other country. And if you can't get that communication for whatever reason, then they err on the side of safety for the country. So I'm going to go to Mr. Arthur. And you have stated in your written testimony 10 different ways to get a waiver. And I was wondering if you would expand on some of those ways for us, and also on the relationship necessary and the communication necessary between officials in this country and officials of the applicant.
Yeah, and if you don't mind, Mr. Biggs, I'm going to answer the second question first. The first one is pretty well covered in the proclamation. And I know this from personal experience. Having been at the INS, I was chief of the National Security chief of the National Security Law Division there for a period of time. We deal with our foreign partners, and when I say foreign partners, that includes countries that we don't consider partners at all, including Russia and China, with respect to information about individuals who are traveling to the United States. They want their nationals to get visas to come to the United States, so they comply with our requests with respect to the criminal information about them. Now, am I telling you that someone who is a member of the Chinese Security Service is going to be revealed as such? No. For that, we rely upon our foreign partners, the Five Eyes, other intelligence agencies, our own intelligence agencies, to identify those individuals so that we can exclude them from the United States. Again, going back to what Director Comey testified back in 2015, I think it was, the vetting is only as good as the information that's available. And I go to the witness from Iran. If the Iranian government were forthcoming with more information, if we could trust the information that the Iranian government provided us, we wouldn't have to go through this process. We would know right away who those individuals are, but they don't, they won't. And that's the reason why we have this problem. So, and again, with respect to the specific limitations, I refer back to that. I'm happy to do it during a second round of questioning, or I can put it in a written statement.
Thank you.
Thank you. The gentleman's time has expired. The gentlelady from Washington is recognized for 5 minutes. Ms. Jayapal.
Thank you, Madam Chair. I wanted to start just by saying that it's entirely appropriate that a witness would quote statistics that are on the website of the State Department. The State Department is required by law under the Consolidated Appropriations Act of 2019 to provide quarterly reporting on implementation of the Muslim ban. The last report that was publicly provided was March of 2019. It is impossible for the public to know what is happening if the State Department is 2 quarters behind on their reporting. So I thank the witness for using the publicly available documentation that is there. And I want to start just by thanking Dr. Dezangi and Mr. Al-Ghazali for your testimony and for being here. We so deeply appreciate it. Your stories, in fact, are the human face, as my colleague Mr. Berra said, that is reflected, frankly, in thousands of people across the country, certainly constituents in my district who are suffering, whose families are suffering from Donald Trump's Muslim ban. To constituents, just as an example, in my district, Rod Cyrus is an Iranian man who's been working as a business intelligence product manager, and he and his wife have waited now for 4 years for the U.S. government to allow her to join him here. Another is Shorey Kobanani, also from Seattle, and she works 2 minimum wage jobs to care for her father, who has a disability, and she's been separated from her Iranian husband for 2 years. And I think the real travesty of this is that U.S. citizens shouldn't have to worry about being reunited with people that they love, with their family members. Green card holders shouldn't have to worry about this. Refugees who are here legally and have applied legally for their spouses and children to come to this country shouldn't have to worry about not being able to be there as a spouse delivers, delivers a child, as we have heard. And so let me start with you, Mr. Dezangi. Could you tell me why you came to the United States, and what made you decide to stay here in this country?
Well, I moved to the United States in 2015 to start my to work as a postdoctoral research scholar at the University of Iowa, working on the impact of non-coding variants on psychiatric diseases. I decided to move to the United States, to join my family, my mothers and two brothers. I obtained my green card on December 2016, 29th. And since then, I continued my work at the University of Iowa. My aim was always to join a family and build my career in high-impact research in the United States as frontiers of research and advancement in technology in the world. It was always my dream to conduct a high-impact research and contribute to the well-being of my community and research. So in this way, I joined my mother, which is a senior citizen. In fact, and also my brothers. It was the aim of our family. And my brother, I have two brothers. One is a professor at Northwestern University and living in Chicago, and the other one is a professor at West Virginia State University, living in West Virginia. And our aim was always to be able to just conduct high-impact research and explore our own potentials and be together with the family. And the reason being is we decided to stay here was because all the possibilities that we had to contribute to the high-impact research.
Thank you so much. So really, you have this very educated family. You came here to join your family, but you contributed your skills to this field, your doctorate degree to this field of high-impact research, helping us, the United States, to really advance our research and technology. And your wife, I understand, also holds a PhD and received a postdoc job offer at the University of Maryland, where her work would have been funded by the National Institute of Health, which, is that correct?
Yes, exactly.
Which sounds like a very prestigious position, and I think the United States would be lucky to have someone like your wife contributing to health research that would benefit so many people here. What options are you considering, and I'm going to ask you to just keep this very brief if you would, what options are you considering in order to be with your family again?
Well, as I mentioned, it's a heartbreaking and hard decision, but I'm actually putting my leave of absence for the university and in the option that I wouldn't be able to join and my wife wouldn't be able to come to the United States and start a career, I will leave the United States.
So we would lose you and your wife. And in my last 10 seconds, Ms. Kara, tell us, what is the harm to the United States? We've talked about the harm to people. But what is the harm to the United States, very briefly?
Yeah, just significantly, there's already been a harm to our economy. Tourism is down. It hurts businesses when people can't enter the United States. Conferences are being held outside. Different data have shown that we've already lost billions of dollars, and that hurts big and small businesses.
Thank you. I yield back.
Gentlelady's time has expired. The gentleman from New York is recognized for 5 minutes.
Thank you, Madam Chair, and thank you to all the witnesses for being here, especially being able to hear the stories of people who are impacted by today's hearing is always helpful for any hearing that we have here in Congress. And Mr. Al-Ghazali from New York, fellow New Yorker, giving you the assumption that you're a great guy, you have a great wife, you have two beautiful, amazing kids, and the goal is to be able to live out the American dream, to be able to escape conditions in Yemen, which we know here. I mean, here in America, we may not know, obviously, to the extent that your family does back in Yemen. It's a really bad situation back there. We do know that here in the U.S. The one thing that you might not take comfort in, because the ultimate goal here is for you to be with your family. That's what you want. That would make you happy. Nothing short of that you'll be able to take comfort in. It was something interesting as I hear your story is, and as the ranking member of the Oversight and Investigation Subcommittee with Chairman Bera, and we have a great working relationship on a bipartisan basis, something that we should talk further about all across the entire world. I have stories in my office where someone is an American They were born in the United States. They're multiple generations here in the United States. They have a clean record. One case comes to mind of someone who's retired law enforcement in New York with a crystal clean record who met a woman abroad and is not from any of the countries we're discussing today. It's actually a country in South America. In vetting the case, I'm not aware of anything at all in her background that would prevent her from coming. And he has applied repeatedly to try to get a visa, just actually to have his wife be able to meet his family, not even requesting permission to stay, just to come for a couple weeks. And that visa continues to, that request continues to get denied. And something that sparked the story too, when you said you went to the meeting only lasted 5 minutes and then it ended. That was exactly the story from a couple of weeks ago, because he and his wife were really excited for this meeting, and it lasted about 5 minutes, and they never got really the opportunity to make their case. And that piece of it is very interesting to me, because and Chairman Bera, hopefully this is something that we can discuss, is the issue that I have with certain countries that are greatly destabilized by the government is the lack of documentation that's provided by many people applying. And then as a tactic, the United States government tries to make up for that through interrogation. And I think that it's greatly unfortunate as far as best practices and visa approvals, and if you're applying for a waiver, to present yourself to the United States government, to take all of that time and travel to present yourself and your wife to the United States government, and for the United States government to take 5 minutes and not ask you a lot of questions, I think is malpractice on the part of whoever's asking you the questions, because you're presenting yourself. You can ask a lot of questions that you were there prepared to answer, and I think that's something that, from a policy standpoint and oversight standpoint, and it was something productive, I think, for this committee to hear. I'm someone too who believes that that this particular ban was discriminating against countries, not discriminating based off of someone's religion, and it's caused a lot of debate and controversy and friction, in Congress and out of Congress, debate in the media amongst the American public, but if you are from Iran, and I know a lot of people who are Iranians, amazing people who are contributing massively to our country. I adore, some of my best friends are Iranian. It's a great nation. If you're from Iraq or Turkey or Afghanistan or Egypt or from Lebanon, then the ban wouldn't have been applying to you. The issue with your wife in Australia is specifically the country of where your wife is from and not the religion. Again, I don't know both of the witnesses. This is the first time we're meeting, first time I'm hearing your story, but I want to say thank you, and I think especially as we hear your personal stories, there's stuff that Chairman Bera and our committees can work together on moving forward on the policy standpoint. So thank you for being here. I yield back.
Gentleman yields back. The gentlelady from Minnesota.
Madam Chairwoman, might I have just 30 seconds to just comment on the Congressman's remarks?
Actually,
Okay.
that's not in order. So
Okay, sorry.
We will turn to the gentlelady from Minnesota.
Thank you, Chairwoman. Judge Arthur, Stephen Miller has repeatedly cited the Center for Immigration Studies to defend his policies. Is it fair to say that you and your organization have influence over the administration's immigration policies?
We are a think tank, so I like to think that we have influence over all policies, including policies of the United States government. Whether anything I write is anything that influences Stephen Miller, I can't tell you.
Thank you. You've said that all 3 reiterations of the Muslim ban are legally justifiable. Various courts have disagreed, usually based on the White House intent. When Donald Trump was running for president, he called for a complete shutdown of Muslims entering the United States. Surely, we have to take the ban in that context. Surely adding North Korea and Venezuela was a cynical attempt to get around the plain truth that this was intended to be a Muslim ban. In my view, Trump's campaign promise to ban Muslims wasn't just empty words. There is a connection between that promise and the subsequent ban. Would you like to see a complete ban of Muslims entering this country?
Absolutely not.
Thank you.
I concur with Thomas Jefferson when he said that.
I appreciate that.
Okay, no.
I have comments. Stephen Miller is quoted as saying that he'd be happy if not one more refugee stepped foot on American soil. He's been the architect of the family separation, gutting the asylum laws, and the increased militarization of ICE and the Border Patrol. He's also attacked our system of highly skilled immigration. Donald Trump has called countries like the country I come from, Somalia, shithole countries, and has wondered out loud why we don't get fewer more people from places like Africa and Haiti, and why we shouldn't get more people from places like Norway. We can conclude that anything besides an ethno-nationalist project from what the White House is doing. They've told us what they want to see, which is for people from white countries to immigrate to the United States. Your organization, the Center for Immigration Studies, has recently published an article asking whether we as a country had forgotten 9/11. There are 2 members of Congress mentioned as part of evidence in that article, Rashida Tlaib and myself. The Southern Poverty Law Center has designated your organization as a hate group, citing your repeated circulation of white supremacist and anti-Semitic writers. The Washington Post has rebuked the research from your organization on terrorism and immigration, and CIS's defense of the Muslim ban. So I don't know how we should take your views and the views of your organization seriously, sir, instead of understanding them as a point of view of a fundamental anti-immigrant ideologies. When you were asked by my colleague Hank Johnson in March, you denied that John Tenton was the founder of CIS and said, quote, "If there is a founder of CIS, it was Otis Graham." In an obituary for Dr. Graham, James Banner credited him for making the environmental case for restricting immigration in 2 of his later books. There was a manifesto from the man who killed 22 people in El Paso last month. In the manifesto, he said that because of the looming environmental catastrophes, I quote, "The next logical step is to decrease the number of people in America who are using resources." This was his justification for the act of mass murder, apparently inspired by the ideas such as those espoused by Otis. I'm appalled by that. Everyone here should be appalled by that. And I hope that you and the founder of your organization are appalled by the fact that you inspire people who engage in such acts. I yield back.
Gentlelady yields back.
Madam Chairman, may I respond in any way to that?
Actually, that's not an order either. So
Very good.
Just as with the Ms. Kira.
I'm
The
just,
gentlelady.
point of order. So what's the rules of the committee if a member chooses to utilize their 5 minutes to destroy a witness? Are you saying the rules of the committee, or attempt to just slander someone who's in front of us?
Going on the record of the words that he used is not a destruction of a witness.
The gentlelady will withhold. A point of order has been raised. Ordinarily, this is a time where members may ask 5 minutes of the witnesses. There's not a time for the witnesses to give speeches, and we will now recognize.
What's the ruling? So I'm just wondering, what's the rules of the committee? If a member chooses to spend their 5 minutes slandering a witness in their organization, what is the rules of the committee as to whether or not the person who gets slandered is allowed to respond?
Well,
if the facts are on the record,
the gentlelady will suspend, and Mr. Zeldin will suspend as well. The rules of the committee provide that under the 5-minute rule, members may question or make statements. It is not a time for witnesses to make speeches. We will now recognize
Point of order / parliamentary inquiry.
Mr. Biggs, you're recognized.
Thank you, Madam Chair. In the past, in this committee, it's been my observation that on occasion when someone has not to engage in debate with the witness per se, but actually has maligned their character and accused them and accosted them or their organization, we've had the courtesy to let them briefly respond to that. I know because I've seen it actually happen, and I'm wondering, I guess my parliamentary inquiry is, since that's been become, if you will, the established practice, if someone has been maligned or their organization, is it not the practice and precedent of this committee, which is consistent with the rules of the House, to allow that person to briefly respond?
Well, actually not, but to avoid a prolonged discussion on this point, I will ask Mr. Arthur in under 30 seconds, if you may, to please make a concise statement, and we will then hear from the next member who wishes to speak.
Thank you, Madam Chair.
Thank you, Madam Chairman. I don't attach myself to any of those statements. I certainly don't. I decry any individual who is, misled, any misguided individual who takes action for any reason. I write about the rules that have been passed by the Congress of the United States and ask that those be enforced. And I always note the fact that Congress is free to change the laws of the United States, sworn to uphold those laws, and I will continue to do so. I'm a father, I'm a member of the community, and I appreciate the opportunity to respond to those statements.
Gentleman's time has expired. We will now turn to the gentlelady from Texas, Ms. Garcia.
Thank you, Madam Chair, and I too want to thank Dr. Denzagi and Mr. Agi Gosling. See, I did that right. Sometimes I'm still called Garza instead of Garcia, so I know the feeling. I just want to say that, and I'm going to read straight out of the Ninth Circuit. I mean, they called this ban, and I'm going to call it a ban because I think we should call it what it is. It was ill-conceived, poorly implemented, and ill-explained. I don't think I've heard anything differently today that convinces me otherwise, and I want to thank you both for coming and having the courage to come share your stories, because I think your story is the same as many that we saw all over the country, all over the world during that time period. And while I do, Madam Chair, I have another question. I want to yield about a minute of my time to my colleague from Minnesota, Ms. Omar, for a brief response, and then she'll yield back.
I object to any notion that my stating of facts is a malignment of the character of the witness. Thank you for distancing yourself from the actions of the person who committed that atrocity, which is what I also said. I want to make sure that people understand I did not make a single statement that was not factual in my remarks. Thank you. I yield back.
Thank you. I wanted to ask both of our testimonial witnesses, what do you think an American looks like? If somebody just said, what does an American look like, what would you say? Doctor?
Well, at this moment, I mean, prior to just like being subjected to the Muslim ban, my dream was always just like a place that you can explore your potential, be with your family, a country that appreciate any contribution to it. But after the Muslim ban and the condition for my wife, the situation became darker for me. At this stage, I'm not quite sure if I am welcome or I'm not welcome, if my skills are needed or not needed, if it is important that I would be with my wife or not, if I'm distressed or not, if my wife got the opportunity to explore her potential or not, any of them are any important or not. At this stage, these are the things that actually distress me, make me sad.
Okay. Mr. Agassi?
Yes, America is the country that gives human being rights. If it's taken away from you, it's the country that protects you. And if you have your vision, you dream, this is where you could pursue your dreams. Your doors is open, chest is open, like a position where I mentioned about my wife. Of her dream, she can't do that in Yemen and anywhere else. This is country, and this is my country. When I was with my wife, before the Supreme Court upholds the Trump administration, she used always to ask me, about this country. I told her I grew up in the United States. I know how America are. They won't throw us, you won't be separated. But when I went home that night, I won't forget it. And she was in front of TV listening to the news and saw that the Supreme Court upholds, and she just started crying, looking at me and saying, I thought you used to tell me that America is this and that, and I still believe the value of this country that's gonna give me justice and bring us together. Thank you.
Ms. Kara, I know that earlier you wanted to respond to a question from one of my colleagues. Do you want to take some time now to respond?
Thank you for that opportunity, Congresswoman. I appreciate it. And I was actually taken by Congressman Zeldin's comments and talking about his own experience with constituents who've gone through the system. And I think it underscores that I think there's a commonality here, which is that I think we can all agree that we don't want to ban babies and grandmothers. That doesn't make us safer. And we need a policy that is smarter and that actually is not doing harm to our own friends and neighbors. And fortunately, there's a solution for that. It's the No Ban Act. And so I encourage the congressman to work with Congresswoman Judy Chu, take a look at that bill. It basically ensures that amends Section 212F authority, the authority the president was invoking here, to more closely track the way that Republican and Democratic administrations have used this authority over the last 40 plus years, where there hasn't been a blanket ban. There's been very tailored, circumscribed bans that deal with a specific diplomatic dispute or dealing with human rights atrocities and trying to address that. And so I am hoping that there can be some commonality coming out of this hearing that underscores that.
Gentlelady's time has expired, and we turn
Thank you,
now
Madam
to
Chair.
the gentlelady from Florida, Ms. Murkasal Powell.
Thank you, Madam Chair, and thank you again for coming in front of us this afternoon. Earlier, I shared the story of one of my constituents who has not been able to bring his father from Syria and the consequences of that. And once again, I just want to remind everyone that we're Americans, whether we were born in a different country or not. You are Americans. I am an American. I had the privilege of becoming a U.S. citizen. I was welcomed under the Reagan administration, and who understood the importance of opening our doors to immigrants, because that's who we are in this country. Unless you're a Native American, we are all immigrants in this country. So I wanted to just ask from the two of you to elaborate a little bit on what does it mean to each of you to be separated from your families, and what does your day-to-day look like?
Well, it's just like living in two different countries, but burden of the life and all the complexity without having the assurance and companionship and support. Being able to communicate just on phone, being able to just talk on a Skype, not being able to have a hug, to be able to just like coming home, have a cup of tea, or just sitting or watching a movie and just like relaxing, and missing all those important moments in the life separate. It's just like when she graduated, completion of her PhD, I wasn't there. When I got my job as a professor, she wasn't here. And all these things are just like big dramas. Our anniversary, our marriage anniversary was 10th of September, and her birthday was 7th of September. I couldn't be on any of them. So these are all dramas. We actually need extra energy to just be able to cope with all the situation and at the same time be productive, because we have responsibilities. I'm responsible for 60 students. I'm responsible for a program. I have to work, and this is my duty, and I would like to do it in the best possible way. But at the same time, I need to put extra time and energy to just cope with all those dramas. And it is harder for my wife. At least I'm here. She's struggling with all the things, and I feel that the sacrifice that she's doing is just like 10 times more than me.
I can imagine. I'm so sorry to hear that. And Mr. Al-Ghazali.
Yeah, the question to be without your family is, I don't know how to explain it, but I got a shortcut explain it. It's just like I live in darkness, and they're the early light. I feel like I'm a bird without wings, without my family. You know, I think about that feeling if I get off work and go home. Well, I want to see my son run up to me when I enter the house and hug me every day. That will leave all the stress and all the stuff that I've been through on the past. And like I said, I still have hope, and we will be together here. Thank you.
Thank you. And Ms. Kara, I'm supporting the No Ban Act.
Thank you.
I agree with you. What other things would you recommend that we can do to help individuals like Mr. Al-Ghazali and Dr. Delganzi to be reunited with their family members? Because we don't get answers from the State Department, from the USCIS offices. We, as Congress members, continue to ask questions. We are not getting enough answers. What do you suggest we can do to help?
So I would say a couple of things. First of all, thank you so much for supporting the No Ban Act, Congresswoman. We now have 177 co-sponsors in the House, and so your support in moving this bill through the Judiciary Committee and eventually the full House as soon as possible would be greatly appreciated. So that's the first thing. The second thing is that what we have found is that sometimes when there is congressional attention and media attention, sometimes that helps get action on a waiver faster. And so to the extent you do have constituents who are raising these issues, please continue to make your voice heard with the State Department, and finally continue to have oversight like this that took place earlier today. It's absolutely crucial. I mean, I firmly believe that the reason we're starting to get movement, we're starting to get some more information from the State Department is a result of not only litigation by groups like ours, but the pressure from Congress as well. So continue to do your job, and because this is fundamentally the province of Congress is regulating our immigration and ensuring that families can be together. So thank you.
Thank you.
Gentlelady's time has expired. The gentlelady from Texas, Ms. Jackson Lee, is recognized for 5 minutes.
Thank you, Madam Chair. I'd like to ask unanimous consent to place in the record Jordanian teen sent to Chicago for detainment after being held in Texas. This is Mohammed, which was a 16-year-old student at Katy High School.
Without objection.
That story evidences where we are today, but more powerfully, the testimony of the two witnesses adds to the overwhelming danger and the overwhelming disaster that has been created by a blanket Muslim ban. The latest iteration of this ban, I note, it seems that it says it is indefinite. That means that my understanding is that people from those particular countries remain in limbo. It seems, if I'm reading it correctly, that Yemen is off the list at this point, and that the and you can correct that if I'm looking at some document that says it is still on. It may be that they're building at each moment. So let me just pose my questions accordingly. Let me ask, in particular, Mr. Al-Ghazali, or I'll just say Ismail. Is that correct, the first name, if you don't mind? And I have been to Yemen, and I know that there are wonderful people there, and I'm enormously saddened by the tragic war that is being fostered upon the Yemenis people in terms of their trials and tribulations. But let me ask how long you are working to get a visa for your wife. She was not pregnant at the time you started, or was she pregnant?
No, she wasn't pregnant.
So you tried to follow the rules.
First time I started applying for her was in 2016.
So you followed the rules to apply, and you were a U.S. citizen.
Yes.
And what was their initial denial, or did they give you any response
A
at that time?
denied letter. They said her visa is being denied because under Section 212F, because of President Proclamation, and that's it.
So you applied in 2016, but you got caught up in the Muslim ban.
Yeah.
How frightened were you? How frightened were you as you and your wife rushed to the hospital, knowing that she could have been in the United States to have your baby?
I don't know, explain that time. It was, I will never forget that time until I die. That's honestly,
Did you think your wife might die?
The way I saw her and the way she was screaming in the back in the cab, and I'm just looking at where is the hospital going to be showing it, and looking at her, it was.
Because you were not in Yemen, you were in Djibouti.
We were in Djibouti. We were not in Yemen. We were in Djibouti, and.
Did you think you might lose your baby?
I was expecting that I was going to lose the baby.
So the Muslim ban has separated families.
Yes.
And in potential put a young woman, married woman to a U.S. citizen, in the eye of potential death, and your young baby at that time in potential death. Yes. What kind of fear ran over you?
I was just I feel like I was just thrown away, but I felt.
No help.
No help.
Mr. Arthur, what is your response to a policy that has no mercy and is ineffective in its structure? Do you think that is the role of immigration laws to rule out the opportunity for innocent persons to create the potential of a baby dying, a mother dying, when the U.S. citizen appropriately applied for the visa in question? Is that what you're advocating here today?
The purpose of the presidential proclamation, Ms. Jackson Lee, is to encourage information sharing by countries and encourage
So if we were to get
promote the foreign policy of the United States.
I appreciate that, sir. That's a blanket response that you're giving. If we were to, in the next 10 days, indicate that we were getting the adequate information from countries, you then could see the wrongness of the Muslim ban.
If we were to get the proper information sharing from those countries, if we could ensure that individuals who are applying to enter the United States not pose a danger to the national
We don't
security.
have proof that we're not getting the right information, but do you see the wrongness or the deterrent effect, when I say deterrent effect, the destructive impact on human beings through this Muslim ban?
All immigration laws of the United States, and I would note that Congress writes the immigration laws of the United States, so to the degree that they keep anybody out of the United States or anybody likes those ideas.
Muslim ban. So let me move to the representative of Muslim advocates, in particular on the Hawaii versus Trump. Part of its decision rested on the assurance that the waiver process would function. In practice, does that waiver process fall short of the Supreme Court's expectations, and why? And also, do you see any merit in Mr. Arthur's point about getting information from other countries when we have the most powerful nation in the world and we can get information on an individual like a pregnant wife of Ishmael?
Yeah. Thank you, Congresswoman, for that question. On the first part of the question, absolutely, the dissent, Justice Breyer was very correct that unfortunately the waiver process has been a sham. It's been now almost 2 years since the supposed waiver process went into effect, and there's still no publicly accessible information to people who are trying to apply and prove their eligibility for a waiver, and there's other deficiencies as well.
Gentlelady's time has expired, so if you could wrap up,
yes.
just finish.
And on the second point around information, I'm going to refer to the 50-plus former national security officials from prior Republican and Democratic administrations who have spoken out and have said that in their expert opinion, there is no evidence of a growing or a particularized threat from nationals of these countries that would justify a blanket overbroad ban that is in this policy.
The gentlelady's time has expired. I will now recognize myself for 5 minutes, and I want to thank all the witnesses for coming here today and apologize to you, Dr. Dezanji, and to you, if I may say Ismail, because I'm not pronouncing your last name very well, for the hardships that you have undergone. Unfortunately, members of Congress have run into similar hardships from our own constituencies. For example, in my district, Mr. Ferris Ahmadi, who's a U.S. citizen, has a wife who's originally from Iran. He has a serious medical condition. He had a kidney transplant in 2016. He requires chronic immunosuppressive drugs to prevent the rejection of that transplant. And according to his nephrologist at Stanford University, his kidney function is approximately 40–50% of normal. He's got all kinds of risk factors, but his wife has been waiting for more than 2 years for the waiver. She's stuck in Turkey, and he's going to see her periodically, even though his doctors are telling him not to do it. It's putting him at risk, but his wife has been kept away from him. I'm mindful, I invited this year to the State of the Union a woman whose U.S. citizen husband and U.S. citizen son were in California, and her son was dying. And she asked for a waiver, and for 2 years got nowhere. Finally, the uproar was such that she was admitted to the U.S. so she could hold her son's hand while he died. She got there 2 weeks before he passed away. So there's tremendous hardships that are being inflicted on American citizens and their families that has nothing to do with the security of the United States. We are hopeful that we, with the help of this hearing, that we will be part of changing that, and also that we will be part of moving forward with this legislation, which I've also co-sponsored. You know, there's been a lot of discussion today about immigration law and the like. You know, I'm mindful that if we don't trust Iran, it's a mystery to me why student visas from Iran are exempt from the ban. Obviously, there's some inconsistency underway when it comes to the American government and their treatment of people from Iran. Questions about how do you establish a hardship? I've often felt that if the U.S. State Department has in their travel advisories that it's too dangerous to go to a place, it's too dangerous to live there, that ought to be the standard for hardship. And yet, we're asking the family members of Americans to stay in places that we've told people from America you shouldn't visit because it's too dangerous to go there. So that's just wrong. I'd just like to make a personal plea to you, Dr. Dzongi. Taking a look at your resume, I mean, it's just an amazing record of scholarship that you have compiled. And I hope that you won't give up. I know that you can apply to become an American citizen, and I hope that you do that. Don't give up on being an American, and let's see if we can't make sure that your tremendously distinguished wife also comes to join you so that she can contribute to the scholarship and advance of science that has helped made our country great. Would you consider that, Mr. Dengazi?
Of course, if you have this opportunity, of course, in this way, we're gonna be here, be with mother, and after 4 years of hard work, building all my career, having my wife to have the best opportunity, we would love to serve this country and serve the academic community as well.
I would just like to know, I've been reading some of your papers, the titles, and improving protein fold recognition using the amalgamation of evolutionary-based and structural-based information. I don't even know what that means. But I would like to say that the 5 pages of scientific papers that you've helped co-author is going to be important for our country, and you are joined by thousands of others who are here in America, who are born someplace else, but our country is about this. It's not where you're from, it's where you're going to that makes you an American. I am so grateful to all of you for being here today, for being witnesses. We will have an opportunity to provide additional questions to you over the next 5 days. If we do, please answer them. And at this point, we will adjourn this hearing with thanks to all. We are adjourned.